Alright, welcome to my office, folks. So I just want to give you a quick lecture on, I'm going to cover basically all of mortuary law from cover to cover, just so that you have a basis going into your national board exam and that you're prepared for that. So here's two books that you might want to check out. One, I know for the class you're using the Pierce-based book, PMC's book. It's professional funeral college, Shea college is what we call it. That's their book. So, but it's pretty. It can be pretty thin. There's not a whole lot in there. It's very, very minimal in its content. So, two books that I would recommend: Larry Cleveland's books. I know you're very familiar with the late Larry Cleveland. Great guy, great books, and he does cover things. And then you have Gilligan, Scott Gilligan and Thomas Steve's book. This you can find in blue or red. They're just two different editions of the same book. These are out of print. They haven't been printed in a long time, so you can definitely find some used ones available out there on the market. You may not be able to see the cover there with the lighting, but there you go. So that's what that looks like. Now, again, you can definitely find those on used. This was the textbook that I had from when I was a student. Still has my rating in it and everything. But the big difference between the books that are out now, whether that be PMC's book or whether that be Larry Cleveland's book, is that they're written like a modern textbook. Kind of very thin and kind of broken up with where they do, but they cover the material and they get right to the point, but not with a whole lot of case studies or examples. So if you're looking for case studies, examples of legal cases, and how some of these legal cases play out, you're going to want to know and look at Gilligan's book. This is very case law heavy, which can be a hard read as far as a textbook, and that is why we do use textbooks like this now. But I'll be honest, the examples, when you're using case law, the examples do go a long way. You don't want to be tested on them, trust me. But they're a great way of knowing what could happen in a funeral home and how to avoid that. So I would recommend that. All right. So now, going through briefly, I'll give you just a brief lecture on these different things. So, first of all, what dictates funeral service law? Where do we get our laws from? We're going to get it from 4 different avenues. Those 4 avenues are state laws and regulations, and that is where most funeral law comes from. It's going to come from the state level, right? We know our licensure comes from the state level. Most of the laws that you're going to have to follow in the funeral home are at the state level. Not the federal, not the local, but state level. Then you have federal law. Now, federal law does play a big role in some of the things that we do. Again, most of the funeral home stuff is going to be state level, but federal law can determine various things, whether it be how you get things, shipping things. We know there's going to be a lot of tariffs placed on goods now. We do get caskets over from China, urns from China that have been ridiculously cheap. Good quality, but cheap products as far as getting those to families. So that is going to impose something on that. But federal law does play a role in what we do as well. The other two, you do have local law. It's ordinances. It's not considered one of these 4 methods, but local law it's not law, it's an ordinance, local ordinance. And a local ordinance can determine what your town would do. Those may come from the health department, that may come from the zoning board. So the zoning board is going to place an ordinance on you. And that ordinance is going to say that your funeral home has to be X amount of feet from the road. That's zoning. Right? That's a zoning ordinance. They can say that you're not allowed to produce X amount of traffic. They could say that you, maybe you have to hide things with hedges. They may place a ordinance on the type of structure you're allowed, things like that. Those are all local things. And then the health department determines where you bury bodies, how you bury bodies, cremations, things like that. They can determine what takes place in their town, what they will and will not allow, as far as, wastewater and things like that, what goes down your flush sink. That's all a local ordinance. But the other two on here, so you have state, you have federal, and then you have case and common. So case law is where you now have a law that is on the books, that something happened, somebody went to court, somebody did something good, bad, or ugly, or whatever it is, but it's on the books, and now the attorney is going in there. The prosecuting attorney or the defense attorney is going to go in there, and you may be on both sides of that case. You may be the prosecutor, prosecuting side, or you may be on the defense side. And in many cases in our job, we're on the defense side. So in that case, those attorneys will go before the judge and say, according to Shea versus the city of Bridgewater, this is what the verdict was. This is what happened. That is case law. That is saying that in this circumstance, this happened. A court ruled in the favor of this. Now, obviously, they're not going to quote something that's not in their favor. They're going to hope the other attorney doesn't find it. But they're going to say, in this case, this is what happened, and we want a similar verdict. That sets a precedent. That is saying that, according to the court, this is what it was, and therefore, if that was their ruling, the precedent is that should be our ruling. And then common law goes all the way back to the earliest days of our country, right? Coming over from England. And, this is stating that common law is saying that we've done it this way. Therefore, there's a precedent that this is just the way you do it. Common law is stating that, you can have common law marriages and things like that. And that's where you probably heard that term used before, is saying people lived long enough, together long enough, we're going to consider them having the legal abilities of having been married, even though they weren't married. The law will expect that because they lived in a marital relationship for so long. But this does apply to other things as well, right? There may not be an ordinance that says you can't litter in that town, but it's expected that you don't litter. Common law could state that it's fairly common knowledge that you don't litter, that you put things in a trash barrel. Common law may say how a procession runs. Common law, a place may not have a law on the books that says that you have to yield for a funeral procession. That's a pretty common thought, right? And it is in state laws stating that you have to do that. But maybe your state doesn't have that. Common law could kick in to just say, we understand that it's the common law that this has taken place. So we do see things like that. Now, as far as disposition of the dead, we deal with a lot of that, right? How you properly dispose of the dead, how do you handle that, and what is the legal status of the dead body, because that defines how that body is treated. Again, if that body is skeletal or that body is in a state of extreme decomposition to the point that they are no longer of human form, they're down to a skeletal mass, they are no longer considered human. Again, do not tell the family that their loved one is not human. We treat them like human, we put them in a hearse, we treat them with all due respect. But that body is, as far as the law concerned, is not considered human, which means that it loses its legal abilities. Now, we could still fight legally for that body, but it doesn't have to go into a hearse, it doesn't have to do all of those. Same way that cremated remains are not considered a human body legally, right? Once you're cremated, you are reduced to bone fragments, and once you're at the point of bone fragments, whether it be aquamation, whether it be alkaline hydrolysis, aquamation, whether it be cremation, whether it be being cryogenically frozen, they basically shake a plate for about 60 seconds, about a minute. And that agitates you and breaks you down after having been frozen. They agitate you, break you down to a mass as well. And all of these cases, including NOR, natural organic reduction, once you're broken down to the point that you're soil, you are no longer considered human. That is soil. That can be treated like soil. Now, there may be other laws that say that you can't grow food in that soil and you can't grow animal food or human food in that soil. It still allows you to grow trees and flowers and all of those beautiful things. But there is laws that say you can't do certain things with that soil. But at any point, I can throw the soil, the reduced, reduced down to compost human is now able to go in the back of my pickup truck. It is now soil. It can go on a tarp in the back of my pickup truck, and it can be delivered as soil in that way. And that is still a respectful way to do that. Now, as far as you disposing of the body, that body does need to be disposed of. That is your job, is to provide proper disposition. Now, you bring in a body, you accept that body. You get the phone call, you go, you pick up that body. That body is now legally in your possession. And because that body is now legally in your possession, that body needs to be treated with due respect. That body needs to be needs to be disposed of. Now you say, oh, but Professor Shea, what the heck happens if that body is, not claimed? We don't know who it is. We don't know who to do it. I can't cremate this body. It's going to cost a lot of money to bury it. What do I do? Right? I don't have permission to embalm. I don't have permission to do all of these things. What do I do? Well, legally, your job is to dispose of that body and to treat it with due respect. Now, on that context, now what you do is you turn around and you say, okay, can we find a family? Are we going to be able to find a family? Is this body going to decompose before I can get permission to embalm? If the answer is yes, then you have two options. Either you seek legal counsel, which is always an advisable thing, and I will never advise you otherwise. Always seek legal counsel. Seek some legal counsel of someone that knows mortuary law specifically, because that is not the most fundamental piece taught in law school, to be honest. So they may have a little bit of a skewed view on how that works. So make sure you get somebody that understands mortuary law. Now, in that, you have the option to, even if you don't have legal counsel, you could turn and you can embalm that body. And you can say, legally, this body, now, obviously, don't say, well, I'm going to embalm the body and we'll go and look for the family. No, this is, if you you can find a family, try to hunt down the family first. Get that permission. But it all fails. You are trying to hunt down a family. You're not able to hunt down a family. You know that there's no family to hunt down, whatever the case may be. And you sit there and you say, all right, look, I know I'm going to have to find a family. There's going to be one out there. Then embalm that body. Prevent decomposition. Prevent issues. Treat that body, care for that body, continue caring for that body until you can find that family. But if you have somebody that you're like, we have no clue where we're going to find this family, we do not have we don't have the ability to get to that family, cremation may be off the table in your state. And cremation may be off because it is a final disposition. We can't cremate if we do not know if that person could find a family and could be provided, there may be a reason they don't want cremated. But in that case, you can still put them in a pauper's field in the back of a town cemetery, basically the low-income section of the cemetery. You put them in that section of the cemetery. There's no markers. They're unmarked. They're just put there. There are some areas where they have cemeteries that will do low-income, where the people are actually not laid out this way, but they're actually stacked up, where they do this especially during disasters. If you go out to the island well beyond the coast of New York City, right off the coast, there is a cemetery on an island. And what they do is, during COVID, this happened, during the influenza pandemic of 1918 to 1920, they did this. What they do is they start just putting bodies on top of bodies. Not bodies necessarily, but they're putting like casketed and vaulted bodies. So the vaults are on top of vaults. And what they do is they backhoe a lot of that dirt. The same way a normal cemetery works, if you don't know how a cemetery works. What they do is they backhoe all of that dirt and they make a mountain in the back of dirt. Then they don't dig down 18 feet, 6 feet, or whatever, okay, depending on if it's a double burial or a single burial. They don't dig down that far. What they do is they're backhoeing a surface level of dirt, about 18 inches of dirt. They remove the 18 inches of dirt, put it in the back of the cemetery. They put all the vaults above ground. They just put all the vaults, concrete to concrete to concrete. This is a normal cemetery operation, not a disaster, just a normal cemetery operation. They put all those vaults. Then they take that dirt with an excavator and they put that dirt on top of the vaults, 18 inches of dirt on top of the vaults. So if you look at cemeteries and you look and go, wow, the cemetery is a mountain, it's a mound. There's a reason for that. It's because they didn't dig down. What they did was they just laid the vaults and then they put all the dirt on top of the vaults. So therefore, that's why it mounds up. That is what you refer to as a pre-vaulted cemetery. They didn't dig down and just put a vault in, because then the vaults, what happens is you land up into a legal issue, and this has happened numerous times, right? This happened in a tri-state scandal. This has happened in multiple cemeteries where they would dig down, especially old cemeteries, they would dig down. Now they're saying, hey, we need to put vaults in these. They could put the vault in for this individual, they put a vault in for that individual, and all of a sudden they go to put in your vault. And when they go to put your vault in, because those vaults are scraping concrete, all of a sudden they go to dig down and they're like, crap. All of a sudden, you ever try to plant a plant and you notice that it shifts, right? Nothing goes exactly where you put it. So the same thing is, all of a sudden they dig down and they realize, like, hey, there's other vaults here. We can't squeeze this vault in. And that's happened where they've had legal issues where they said, all right, we'll make the body disappear, say it was in there because we couldn't do it. Okay, this is also why funeral directors, your job is to watch that body go down, make sure they put the vault cover on. Nobody leaves that cemetery. There's a funeral director assistant. Somebody needs to stay there and make sure that that vault went on, that cover went on. Make sure that vault is there. Make sure everything works. Make sure that the dirt goes on that grave. Whatever the case may be, but you need to make sure things are done properly. Do not have your name attributed to a problem. But in this case, they're piling. Instead, what they're doing is they're backhoeing all that dirt. But in the disaster case, they're putting vault, and then they're putting another vault, and they're just basically laying all these people over the entire plot that they've designated, putting all these vaults, and then they put another layer, and then they put another layer. So they're basically creating vault mountain vaults. They're just layering them on top of each other. So you're not going to get to the ones on the bottom. They're putting all these vaults, and they're just basically layer and layer and layer and layer and layer. And then they eventually, when they're done, they put dirt on top. And that's perfectly legal and that's perfectly fine, and they can do things like that. So, but what's going to happen is if that person is, obviously they're buried in a situation like that and they're at the bottom, you're not getting to them. But in a normal cemetery where they are burying them individually, then what's going to happen is that family contacts you and says, hey, we've done some research, we think you have my mother, we've been estranged, whatever, but we do want to give her a proper burial, or we wanted her cremated, we want to make jewelry, whatever the case may be. And in those circumstances, you're still able to exhume and disinter that body, and, provide them, put that in a place where they so choose, or cremate, or do whatever they so choose. Right? But at the end of the day, your job is to provide proper disposition. So if you can't find the body, do not hang on to it in the garage or the prep room and just hold on to it saying, we're going to find the family someday. The best thing to do is to take that body and put them into a cemetery, or put them into a temporary holding vault, holding tomb at a mausoleum. They do have those, some old mausoleums. If you look at some of the older cemeteries, or if you look on the side of the road when you're driving along, sometimes it's in someone's front yard. All of a sudden you see along the road, and especially in the more rural areas, you'll see some doors and this like archway over it. That's a burial vault. That's a tomb. That's a crypt. And what that is that's where your family would go. You would put your for that house, for that family cemetery. They can't dig into the ground. We know about winter burials, right? They could not dig into the ground. So what they would do is they would put you there for the winter. Then come spring, they were able to take you out of the temporary crypt, and they were able to make a proper burial. Not that that was improper, but they were able to make a burial. And we still have these. We still have, maybe on the side of the road, we don't tend to use too many of those anymore, but we do have them in certain town cemeteries, still do have those. The best thing to do is say, look, if this is temporary, we know we're going to find the family, do not leave them in your funeral home rotting. That will open yourself to legal issues. But if they are in a temporary mausoleum, temporary crypt in a town cemetery, they are in a cemetery. That is proper burial, and bodies can decompose in a cemetery. That is allowed. So you have done the proper thing, and that is the best way to go about that. Now, proper methods of disposition, again, things may not be legal in different states, right? We have cremation is legal in Massachusetts and the surrounding states. We have, regular burials is legal, but then there's different legalities over where you can do that, right? Rhode Island, New Hampshire, some of the states you can have a crematory attached to your funeral home versus Massachusetts you cannot. But NOR, alkaline hydrolysis, those are all on the books to be legalized, right? They are going through the legislature right now in an attempt to be legalized, but they're not there yet. They haven't been legalized yet, so we can't do that. Could you still do those? Yes. Right? You have a body here in Massachusetts that wants terramation. They want natural organic reduction. You put them on a plane. You send them to Washington State the same way you would send them to Washington State or any other state for burial or for services, or they would ship them to you. The same way you put them on a plane, they go to Washington State. A company like Return Home goes to the airport. They pick up. They do have funeral directors and staff. They go and they pick up the decedent the same way you normally would. They went in a shipping tray. They went out there. They do the services out there in Washington State or Colorado or wherever you send them to where it's legal to do this. Then once that process is done, about 90 days later, then they now get put that soil, that compost gets put back into the same shipping tray that you sent them in. They get put in there. You get about a cubic yard, about 9 to 12 bags. They put that on there, and then they send that back. That is treated like human remains as it goes back on the airplane. But when that arrives, you can put that, and I would recommend that you show up with a hearse or a van, and you treat that, bring that to the funeral home, and demonstrate to the family that their loved one was treated. But they could show up to the funeral home with a pickup truck, take the bags of soil and put that into the back of their pickup truck or their minivan and drive off. That is soil. They do not need a special vehicle for that. That is not considered human anymore. Don't tell them that's not human, but it's not considered human anymore legally. The same way you go to the airport, you could open and say, yeah, I don't need that container. And you have your pickup truck, again, be respectful, but you have your pickup truck or your dump truck or whatever you want, and you were to say, all right, open the container, put them in the back, all right, you guys can dispose of the container that they came in. Legally, you could do that. Again, I would be respectful, but just on a legal note, I'm telling you what the definitions are. Again, shooting people into outer space, Viking burials, we've gotten a lot of questions, at least I have, over Viking burials. People, I want this. Yes, it's exciting, putting somebody on a raft and lighting them on fire. But we've had a lot of issues, not necessarily locally, but we've had issues. There are some states that do have that legalized, where they decided when they legalized it, they said, we're going to legalize it within this context. Viking burials have to be, which is considered an open air burial. That's open air cremation, sorry. Open air cremation. Viking burials are open air cremations. So they said, you can do open air cremations, but we're going to restrict how that takes place. And that is good. That's how the legal system works. And that is how an effective legal system works, is by restricting that so that you have to say, this can be done, but it can only be done under these contexts. What you do is you prevent people from doing stupid things. For those states, you have to go to you go to a place that has like this pavilion, nice place where you could be married, or, think of the National Cemetery in Bourne or some of the others where you go out and there's a pavilion, right? You do the services under the pavilion, and then they literally, once the family leaves, they have an actual dump truck that they load you on the back. They load the casket on the back of, and they drive. That's how they drive the casket out to the cemetery plot. But the pavilion's a nice place for a ceremony, and that's the same thing. You go to these places, these open air cremation locations in some of these states that allow that. They have these pavilions. You have the service under the pavilion, and then the individual is brought out to a funeral pyre, which is next to it. And the funeral pyre is exactly as it is. It's an open thing that's you can put the body on top of, and as the body straddled, you light the fire. You put wood and whatnot underneath it. Now that does take a lot longer than cremation. Cremation in a retort takes about 3 hours most. But with this case, this is an all-night procedure. And what they'll do is they will have fire tenders. A lot of times these be volunteers actually, um, and we see especially volunteers when you're dealing with like the native population, indigenous population. They will do a lot of these because that is part of their religion, part of their traditions, which is absolutely beautiful for them to do this. And what it is the indigenous community is they have volunteers that will do this, and they'll do it on the reservations. And for those volunteers, what they do is they tend that fire all night long. So there's people that they take shifts, they get relieved, but their job is to tend that fire and keep that going because you obviously you have to get that body down to a point where it's completely reduced. That is the law requires that. But what that prevents is having people put out on a raft because we have had issues with this, where people put the body on a raft out in their backyard, out on their lakefront property, and they said, "This is what we're going to do." They send it out. They dump it in gasoline. They have fun. They think they're going to put fireworks underneath it. We'll have a celebration with this person. What does that turn into? That gasoline just burns. Kerosene burns all of that. But the issue is now they're putting fireworks and they're putting other combustibles that explode. And we've had reports legally. There's been cases where mental anguish cases, negligence cases, where things have exploded and sent body parts into other people's lakefront properties on their beaches, and they wake up in the morning and there's arms and legs and heads on their property, and that is not something a family wants to wake up to or should have to be exposed to. So that's where the legalities are preventing things like that. So as a funeral director, where do we come in? Part of ours is saying, yes, we can do this, but this is the context in which we can do it. Or, no, that is not legal. However, that's not legal here. However, I can send you to this state, in this state, Minnesota, Colorado, Washington State, all of these states. This is where this is legal, and this is where they have centers. Now, natural organic reduction is legal in Vermont. It is legal in Maine. It is trying to go through the legislation in Rhode Island and Massachusetts. Now, here's the thing. There are centers in New York where they have to be in a cemetery. The composted remains in New York cannot leave the cemetery. Okay? That's what we're risking in Massachusetts with NOR, is that because cremation and everything else is only legal in a cemetery, it is highly restrictive. I know we have a lot of people that are very interested in doing NOR. They want to start NOR. I'm all for NOR. I'm really excited about terramation. I love this process. But the thing with Massachusetts is you can't be entrepreneurial with NOR. You can't just open a NOR center, terramation center in Massachusetts. It's going to have to be within a cemetery, just because it's going to follow suit with crematories. It's going to be within a cemetery. That cemetery is going to have to be around for X amount of years. So you'd have to own the cemetery first, and the cemetery would have to be. You could start a cemetery, go buy property, start a cemetery first, if that's what you want to do, and get that cemetery to be old enough that when terramation comes about, you can bring this into your cemetery. But you're going to have to do it in the cemetery. But here's the thing. So we have it legal in New York, but anything that's terminated cannot leave the cemetery. So the soil has to be spread in that cemetery, cannot leave. So that's very restrictive. I think New York is the most restrictive right now for NOR. But here's the thing. It may be legal in Vermont, it may be legal in Maine, but there is no centers in Maine or Vermont to bring your body to do NOR. So you're still, even though it's legal, until there are locations to do that, we're still sending bodies out to Washington State or Colorado in order to make this disposition. And that's perfectly legal because it's legal in the state where the disposition is taking place, not necessarily where you're doing the arrangement. Now, when we talk about rights of custody, so again, one of the fundamental words that you need to know is that bodies are considered quasi-property. Okay, they're not anybody's property. Nobody owns the body. It is quasi-property. Quasi-property indicating quasi means somewhat or part of, and because we have quasi-property, the body has its own rights, and the family has rights over the disposition of that body. And the family can sue you if you don't care for that body properly. The state or federal governments can sue you for not properly, mostly the state or the local governments can sue you for not taking care of that body properly, because they have quasi property. Again, the body owns itself in some regard. But when we talk about custody, we're also talking actual custody and this abstract level of custody. So when we talk about that, you have two different things. Okay, so we have the custody of who has control over the funeral, and then we have control over the actual body, rights to choose the disposition, and ultimately the funeral director has the rights of disposition. Okay, and what does that mean? That means that the funeral director has the obligation to provide disposition. So if that family was found, not just the family, if anybody found out that you did not properly dispose of that body and you're hiding them in walls, like we're seeing in Colorado and Florida and some of these other places, then you did not do your job. That is part of the big issue, right? And the contract that you sign with that family, that funeral contract, is stating that you are going to provide that service. That is stating that contractually you're obligated to provide what you did. But even if you got a call in the middle of the night, you went and picked up that body, you brought that body into your care, and when you brought that body into your care, there was no contract, there's no family, nobody has signed anything. That is an implied contract. Okay? That is implied that you are going to provide services. May not be this grand service, funeral, all that. You don't have a family to do that for. But it is implied that you're going to provide care to the deceased. That's implied. That's an implied contract to the point that you're going to provide that. Okay, and you are legally obligated to do that. Now, in this case as well, when we're dealing with the right of custody, we have absolute custody. Okay. And we have this basically control. You have control over the body and control over the rights to the body. Is what that comes down to. Okay. So the two terms we use for possession is actual possession and constructive possession. So the funeral director, the embalmer, the funeral home has actual possession of the deceased, but the family has constructive possession of the deceased. They don't actually have the deceased. They don't have custody of the deceased. The same way that if I give my vehicle over to the auto garage, and when I do that, they have actual possession of my truck, but I have constructive possession of my truck. I don't have my truck right now. It's in the garage, right? It's getting fixed theoretically. And because it's getting fixed, they have the actual possession of it. But I have construction possession. I possess that truck. That's my truck. Okay, so if they do anything to that truck, that's still my possession. I still own it. It's still my possession. In this case, we don't own a body. But in this case, the family has constructive possession of it. Right, and those are key words you're going to want to know: actual possession versus constructive possession. Those are very, very important cases. Now, here, let me give you a legal case for this. Okay, that's why I'm flipping to this page now to give you this. So, in this case, we have Pierce versus the proprietors of Swan Point Cemetery. That sounds like a familiar case. Swan Point Cemetery, where's that? Oh, that's in Rhode Island. Okay, very local situation. This is a local case. This happened locally. Okay, so this happened against Swan Point Cemetery. All right, so the case reads, Swan Point Cemetery 10 RI 227, if you want to look it up. Okay, this is the case name. Although, as we have said, the body is not property in the usually recognized sense of the word, yet we may consider it as a sort of quasi-property. Again, key word that you're going to need to know, for the rest of your career, quasi-property, to which certain persons may have rights, as they have duties to perform towards it. arising out of our common humanity, but the person having charge of it cannot be considered as the owner of it in any sense whatsoever. He holds it only as a sacred trust for the benefit of all who may, from family or friendship, have an interest in it. And we think that a court of equity may regulate it as such and change the custody if improperly managed. Okay, so that it was the court decision that came from Pierce versus the proprietors of Swan Point Cemetery. Right, so that we also have cases that pertain to the right and control of the funeral. So in this case, if you want to look this up, it's Rader versus Davis, 154 Iowa 306, 134 NW 849. This took place in 1912. Okay, so we're talking a while ago. All right. A husband and wife had been divorced. The custody of the couple's only child was granted exclusively to the wife. When the child died, the wife refused to allow the husband to attend the funeral. The court upheld the wife's decision and to exclude the husband, stating in part, there was no duty, as we understand it, however, to conduct a public funeral, and if there were, private funerals are so common in this country that we would not feel disposed to say that public services are required to be held. There is no implied invitation to anybody to attend a funeral conducted from a private dwelling unless it be announced that such funeral is public, and even is so announced, the invitation may be revoked and anyone denied the right to attend those presents might be objectable. Those present might be objectable. Is the way that worded. All right. So, in that case, what do you do as a funeral director? Right. You have a couple different cases that this happens all the time. Right. One, if the family wants it private, make it private. Do not put the obituary. Now, they may have an obituary. They can publish it after the service takes place. I've done that many, many times over where the obituary didn't hit the newspapers. They still want one, but it didn't hit the newspapers. It did not go on the website until after services took place. And then you can legally exclude anybody you want. Now, the key thing with this is make sure that families are aware that they do need to invite the people that they do want, because I've had many services where it was private, and I said, make sure that you do it. Oh, yeah. And then they show up and they look around and the family is sitting in the fancy chairs. That's like the chair I'm sitting in right now was a family chair at a funeral home that I acquired. But the, so sitting in the fancy chairs all along the edge, and they're looking around and there was literally nobody. There was nobody there. Why? Because they failed to invite them. So you need to make sure that they are still inviting the people that they want and that they know they have to invite them. That people don't just show up. Now, we have a public service. Now, we may want to leave details out. We could leave a thing and just say the person died, and you can put in the obituary that services are private. And then, therefore, maybe they have to contact the family and ask the family or ask the funeral home. Now, be careful. If they're private, don't be answering questions from the funeral home. Oh, yeah, I'm the great aunt. Yeah, okay, sure you are. So, we don't want to give out that information. If they're private, they're private. But if they can call the family and they can find out when the services are from the family, but you can sell the obituary. If those services are public, then you can have a list of people that you say, these people are excluded. These people are not allowed at the service. And you can tell your funeral assistants, like if you see someone that looks like this, they are not allowed inside. The family has exclusively asked, here's a photo, they are not allowed inside. I've had people that made it in that were not invited. We were not told to exclude them. We were not anything like that. They made it in. Family had a fight in the hallway with this individual, kicked them out, and they took a big black Sharpie and crossed their name out in the register book. That all happened. Okay? All behind us. No police, nothing. But if you think that there's somebody that's going to show up that is going to be threatening to the funeral home, have police there. The family will have to pay for it. Minimum 4 hours for a police of detail, by the way. It's usually around last time I checked, it was about $60 an hour for the police detail. I'm sure it's gone up by now. And it was minimum 4 hours. So the family has to pay for that. It doesn't mean the police is there for 4 hours. It just means you have to pay for that. And you just say, look, we don't feel you have somebody that's going to come in. They're threatening. How threatening is the person going to be? No, they'll be fine. Person just might show up, but they're not going to be an issue. Cool. Okay, we'll just tell them to stay out. But if that person's going to be a problem, insist that you have the right to insist that the family. You say, look, we do not have the ability to police the area. We can tell people, but we don't have the ability to police the area. We recommend that we get a police detail, and the police can work the doors, and they will be here if something happens. Then that way the police can be the ones to say that they're not allowed there. That keeps you out of legal issues, and keeps everything going as well. To another court case that took place along those same lines. The courts have made clear that the right to exclude others from the funeral extends even to services conducted in cemeteries. Okay, so Ross versus Forest Lawn Memorial Park. Now, Forest Lawn, by the way, is one of the most prominent and most expensive funeral homes and cemeteries. It's a combo. The funeral home is in the cemetery, in the country. It's absolutely beautiful. I've been there. Professor Mirasu actually did his apprenticeship there. Absolutely beautiful. It's in California. This is where the stars. This is Hollywood. This is where the stars are buried. So this case took place in 1984. The facts showed that the mother of the deceased instructed the cemetery that the funeral was to be restricted to invited guests only. Now this is the Forest Lawn Glendale, by the way, has the tallest gate in the world. Just so you know, just give perspective here. The mother was especially concerned that unruly companions of her deceased 17-year-old daughter would disturb the funeral. The cemetery orally agreed to take all reasonable steps to comply with the mother's request. Now, remind you, the cemetery and the funeral home are the same entity in this case. Okay, that's how this works. The funeral ceremony was completely disrupted by the deceased friends. They attended the chapel services and the graveside services in outlandish outfits, which the court described as not in accord with traditional funeral attire. During the services, they drank and used cocaine, physically and verbally abused guests, and created a disturbance which had to be settled by the police. The mother sued the cemetery, alleging negligence and breach of contract, and claiming damages for mental and emotional distress. Okay? The California Court of Appeals upheld the validity of the mother's complaint. The court first noted that the mother, as next of kin of the daughter had no spouse or children, had the right of disposition. The right of disposition, according to the court, included the right to determine the time, the manner, and the place of burial. The court then examined case law from other jurisdictions and concluded the right to determine the manner of burial gave the mother the right to exclude others from the funeral. So now going back to other cases like we just mentioned and saying, hey, look, that case comes up and says, hey, there's a case on the books that said you can do this. In reaching this decision, the appellate court cited Haney versus Stamper. Okay, this took place in 1939, wherein it was held that a widow could rightfully exclude the deceased brother from the funeral. Okay, and it continues on. There's more. Okay, that the mother had the rights to do this. So just to give you an idea, this is just how it goes. I should probably read you from the rights of custody as well with that, where that came from. But the what else do we have? So we have, going on to the rights to choose disposition. Same thing is that this is a key word and key sentence right here. The paramount right to take custody of the body includes the right to choose the method of disposition. That is a statement that I'm reading verbatim because that is a statement that you need to commit to memory. That those are key words, okay? The paramount right to take custody of the body includes the right to choose the method of disposition. That goes to the next of kin, okay? So, therefore, the person found to have the paramount right has unfettered discretion in selecting if the deceased will be buried, cremated, or disposed by another method. This means that that person, the next of kin, or the spouse, again, next of kin is not spouse, so spouse or next of kin, it was in that order, has the paramount right of disposition. Those are key words you want. The words are paramount right of disposition. Okay? Key words you want to know. That's the definition you need. That does not go to somebody that has a rights of attorney, a healthcare proxy. It doesn't go to any of that. Okay, you take all of that. So we have now some states will accept somebody that has legal proceedings that say that they have the right. Okay, so the court could take rights away. They could say the mother is insane. The mother has no rights. The spouse has no rights. The spouse has been estranged and separated from the deceased for the last 20, 30 years. The children have always been there, but the spouse, they never got a divorce. They never went through they never spent the money that it takes to get a divorce. That is expensive, so they never spent the money. We have a lot of people that are still married on the books that never went through that. They just said, look, it's not worth it. We're not going to go through that. And that's fine. But at the point of death, the person that needs to sign that paperwork is ultimately still the spouse. The children can go to court, and I would recommend, if they want the right, just say, go get an attorney. The attorney will file, it's just, you don't have to go through the courthouse and all of that. It's just the attorney will file the paperwork with the court that says we're seeking the right to have these children have the paramount right of disposition under these circumstances. And the court can rule that. Now, you have to be careful because when it comes to embalming, things like that, we may have a decomposing body by the time the court takes their decision. That does take a long time. So we need to expedite things and say, look, I got a body that's decomposing here. And maybe the court can make an emergency ruling to say, while we settle this, you can embalm the body. Get that permission, say that you can embalm the body, and then they can continue making their decisions over who can get the paramount right to disposition of that body. But don't be afraid to ask legal counsel for advice there. The money you spend on legal counsel will save you multitudes more on legal cases. All right. So Dupin and Shea versus Duke University. This took place in 1984. The next of kin elected to have the decedent cremated. However, the executor of the deceased will, noting that the will had expressed decedent's wish to be buried in Ohio, countermanded the cremation order and had the deceased interred in Ohio. When the next of kin sued, the court held that given the deceased instruction in the will, the executor had the paramount right to arrange the disposition. This being the case, this decision to bury the body rather than cremate it was well within his right. Okay, so here's two different things. You put it in your will saying this is what you want. That gives paramount right? You put it in writing, you sign that said what you did. Here's the issue that you're going to face. This is what you need to advise families. Is that all of a sudden that next of kin says, I want the person cremated. And why? I've had families that came before me and they said, I want that body cremated because they were looking at what they were going to spend the money on. There's money. Why am I going to spend my father's money on a funeral? You're not getting my money. I want that money. And I've had that same conversation with families. They argued that. And other people are going, he wanted to be buried. I know he wanted to be buried. No, he's being cremated. Okay? They look at it as the cheap way out. And that's sad, but they do. So at the end of the day, all of a sudden, your will is there. Well, here's the problem. The will is not open for 3 days. Usually about 3 days after the death. After the burial, sorry. After the person's buried, then about 2 or 3 days later, the lawyer actually opens the will. That is not the place to be putting your rights. If the person wants something specific, have them do a pre-need. Have them sign that pre-need. Have them put that there and put it in the file. Because now the funeral home can say, Your father made a choice. Now, does the paramount right go to, yes, the next of kin can change that. They have the right to change that. However, the deceased did put their decision in writing, and if everybody else argues and says no, Dad did not want that, then the vote does go legally towards the fact that the pre-need was written and did state something specific. So again, I always do that. I've had this happen more than once where someone came in and said, I don't like my children. My children are not going to make a good decision for me. And they came to the funeral home insistent, like on a rampage. They were on a vendetta to say, I don't want my children to have any choice in the matter on what happens to me. And I hope they didn't. I hope this decedent got what he wanted. I really do. I did the pre-need, and if he was on his death, I think he had cancer or something. He was looking at his end of his life because of that. But he wanted his plans on paper, and he said, I want my children to help. And I had already left the funeral home. I never buried him while I was there. He had, he must have died well after I had left. So hopefully he's still alive. We really do hope. I'm not going to make a bookcase. Hopefully he's still alive. But in this case, I wrote right across the paper for his. I said, under no circumstances is anybody to change this will. Sorry, not change the will. Sorry, under no circumstances is anybody allowed to change this. This pre-need everything. I wrote it right in Sharpie, right across the cover. I said, under no circumstances anybody to change this. Under orders of the, under orders of the deceased or whatever I wrote. Under so and so. I wrote his name. Under orders of so and so. And then I signed it. I wrote it right across it. Signed, funeral director Dan Shea. And I had him sign it. Now, does that mean that the family still couldn't change it? No, they could still change it. And they very well could have. But we hope that they saw that. We hope that they saw that and said, oh, my father was that insistent, I guess we can't change it. Now, when I go before that paper and say, oh, this is the I would say, this is the pre-need, this is what your father signed, he was very insistent that it not be changed. Now, if they wanted to change it, they change it. But you would hope that without letting them know, not that you're holding information from them, but without letting them know straight out, like, okay, well, here's what your father wanted, but you can still change that. Right? I would just say, this is what your father's wishes were. I didn't tell them otherwise. I would just say, this is what your father's wishes are. And at the end of the day, they fought it, they fight it. But at the end of the day, you would hope they turn and they go, that's what Dad wanted, that's what Dad's going to get. Right? So, then we also have the funeral contract. So, within the funeral contract, you have, obviously, in general, that contract is an agreement between you and that family that you're serving. Saying that you're going to provide services, and in turn, they're going to pay you for that. But you do have to have very specific disclosures on that paperwork, right? So, those disclosures saying that embalming is not required under certain circumstances. Now, you do want in that disclosure that says, yes, we can embalm if this is, there's certain cases where this body cannot go in the front. We don't have to embalm if you want to go directly into the ground. We don't have to embalm if you're going to the crematory. We don't have to embalm if you're a body going into the front of our parlor, but you're not under certain circumstances. But you can say that we do reserve the right, as a funeral home, we do reserve the right to deny an open casket service if you're not embalmed. Now, I'm not saying that we're going to enforce that in any case. No, that body legally can go up because now the court of law is going to look and say, Mr. Funeral Director, what was your reason for not allowing this family? It says it's not required, but why did you not let that family do their services with an open casket with an unembalmed body? Was that body in a state where that was not a safe case? No. Then you're not in the right to do that. But if I could turn around and say that is securing the public's health, then yes, I can say that. I can say that body's in a state of severe decomposition. Yes, I can do that. Right? I can say I'm not able to do that. I can say, look, if you want to do that, you're going to sign a paper releasing from indemnification and all of that. You're releasing the fact that you will not sue me for mental anguish. You will not sue me for negligence. You will not sue me for any of these things because I did warn you that this body should not be up on the front. If I had any unembalmed body, I want to have them sign for anything because guess what? Unembalmed body means that could purge. It could leak. It could start. I could have a good body and all of a sudden starts decomposing. I could have issues if that leaks. If that's what you want, you're going to sign a paperwork stating. Now, this is a closed casket and everything like that. I'm not going to have them sign paperwork. But if that's an open casket and they're viewing that, they're signing paperwork. Just not that something's going to happen, but just to release me. Now, back to disclosures. You do have to have the price of the funeral and the list of all the services and merchandise included. You do have to have the price of each supplemental item of the service in merchandise on there. You do have to have a list of the cash advances made by the funeral director on behalf of the person making those arrangements. Okay? Now, could those cash advances be raised in fees? Yes. But you have to have a disclosure saying that these types of cash advances are raising the fees. Now, should you be doing that? Normally, no, but it may be it costs something to provide that cash advance. So you're able to raise that because there's an expense to the funeral home in providing that. Okay? So you're not adding on, you're adding on the extra expenses beyond what they see on the as the actual expense. And method of payment, all of these things. All have to be on there as part of the truth in lending disclosures and things like that. Right? Now, different terms that you definitely want to know as far as what should be on that contract. Itemization. Okay, everything is itemized on there saying broken up. You can have your basic service fee. That is a grouping of a whole bunch of things. That's kind of saying other. That's really what that is. That's all the other things that's going to cost me that, the lights over my head, all of the unrealized expenses, the lights over my head, the gas for the vehicles, all of these things, the administrative expenses, all of those things are unrealized expenses. That becomes what we call the non-negotiable basic service fee. But you have to itemize everything else on your GPL. But does that mean you need to itemize everything on your contract? No. Okay? Packages allow for you to not have to do that. So you itemize everything. You have to itemize everything. But if you have a package, then you can write on the contract, blue package, green package, signature package, premier package, Commonwealth package, whatever you have. And you can put that on there as a package. But if you don't have package, you itemize it. If they break the package, right? So again, a package would be under the circumstance that I walk into the funeral home and I hand you that GPL, and on that GPL, you open it up, and then you have a page that's the Commonwealth package of another one, that's the Premier package, another one's the Signature package. Now, they're all the same. They all provide a memorial video with 30 photos. They all provide 50 prayer cards. So they all provide one limo, one hearse. They all provide maybe a seed packet. They all, to grow a tree. They all provide a certain amount of funeral assistance. They all involve, calling hours the night before, a funeral, quick, like 15 minutes or whatever, whatever you want to provide, half an hour before you leave for the church to gather everybody the next morning, go to the church, go to the cemetery. It includes all of that, okay? Everything that you would consider to be a normal service, a stereotypical normal service, would be included in your package. And the only difference between these packages is one item, and that's usually going to be your casket or your urn. So so I look through the merchandise room and I say, okay, when I bring the family down, I do all the arrangements, I get all the information, the churches we're going to, all of that stuff, demographic information. And then I look and say, okay, out of all this wall, on the signs that you see on the front of these caskets, or the sandwich signs in front of all the urns, what you're seeing is all of the ones that have yellow tags are going to cost you $3,000 with everything else included. All the ones with green tags are going to cost you $5,000 with everything else included. The ones you see with blue tags are going to cost you $8,000 with everything else included. You get the gist here, okay? Red is like $15,000 with everything included. Okay, we're jumping up to the presidential and gold and bronze caskets. The only thing that changed between all of those caskets was the casket. That's it. Okay? And we may have 2, 3, or 4 caskets that have that color or that name, the Commonwealth. You know, you have a tag that says Commonwealth, one that says Signature, one that says Premier, one that says whatever. And you have 2, 3, 4 caskets that fall under that. Okay, under that package. And then on the side of that package, you have an option that says if you have same-day visitation. So instead of having calling hours the night before, we now have whatever you want, an hour or 2 hours the same day, which means I'm calling all the funeral assistants in the same day. It's going to cost me less. We don't have anything going on the night before, which was like 3 or 4 hours the night before. Everything's the same day. Now that $3,000 package is now $2,300 or something. I'm just don't quote me on prices here, but that's gonna throw down your price on that. That's whatever it's gonna cost you. So all of those things. It says here if you want a lower cost, you can do a same-day visitation. What you're doing is you're making this visual to a family rather than saying, all right, well, what do you want? You're at the arrangement table and you're making an agreement. You're like, oh, what do you want? Well, we want calling hours the night before, and we want this, and we want all of these things, and they're picking all this. And then at the end, you itemize all these things up, and you're like, that's going to cost you $20,000. I don't have $20,000. Now you're trying to go back and you're trying to explain all these itemized things. You're not having a conversation with the family over who their loved one was. You're not having a conversation with the family over what should be in the obituary. You're not having a conversation. You're having a conversation over itemized items that don't make any sense to a family. They don't. Okay, they're on there. The one thing with the FTD, they don't make sense to a family. The GPL is the most confusing thing that could possibly happen in a funeral home. They don't understand it. Okay, you don't walk into a restaurant and you look at the menu and say, I want a turkey club sandwich. That's what you say. And then in addition to that turkey club sandwich, you'd say, I want a turkey club sandwich with no mayo. Or I want a turkey club sandwich with, can you add jalapenos and mushrooms to that? Yeah, no problem. That's going to be an extra $2, $1 for each ingredient that you add. Oh, okay. I'll pay it. Cool. I'm good for that. But it's the same thing when you walk into a room, right? That menu did not say, you didn't look and say, all right, now maybe you go down to local Chipotle or Fiesta or something like that. Yes, you may do your ingredients piece by piece, right? But you didn't really do that. You chose kind of the content. You said, I want a bowl, a salad, a taco, a burrito. That's at the precedent of what you're going to get, of how you're going to get that. Then beyond that, it's Mexican food, guys. Okay, you're going to a Mexican restaurant. I can summarize Mexican. I love Mexican, by the way. That's my favorite food. But you can summarize a Mexican menu by what? What do you want it on? Do I want it on the plate? Do I want it on flour? Or do I want it on corn? Now the next option. Do I want that flour or corn hard or soft? That's literally your entire menu. And then what do you want on it? Pick your meat and pick your vegetables and legumes. Okay? Just tell me what you want on it. You got a burrito, a taco, whatever you got. Okay? What sauce you want on it? That's Mexican for you, okay? But at the end of the day, the family came in with a grouping, right? You knew what you wanted, and then you picked your ingredients. But it's the same thing with that, right? I don't look at the turkey club and say, I would like a bread, a lettuce, an onion, a tomato, I want bacon, no, you don't want turkey club, okay? So it's the same thing. When the family walks in, because nobody wants to sit there and add up every ingredient that's going to be in their sandwich piece by piece, and they don't want to do that with your funeral either. What they want to do is they want to walk in, they want to say, they do all your arrangements, they're happy, and then rather than itemizing it, realizing they're over and they don't know where that is, when they look at that sign, they can visualize it. They say, everything on here comes for this price. What they're doing is they're going to lower the casket that they chose. They're not lowering the services that go around that. The services are what brings people back to your funeral home. That is what makes people happy. That's what gives them a good impression of your funeral home, not how pretty the casket was. Okay? So, and families, they gotta have the best for mom, and then they don't have the money to do anything else because they got their heart set on that. So when they go into the merchandise room, what they're doing is now they're setting their eyes. They already know the services are included and everything else, but they're setting their eyes on the caskets that they know are within their price range, and they're not bothering to look down in the rate category. But now you say, well, how do we do this if the person does want to do like the food menu and say, I want to add mushrooms, I want to add, I don't want mayonnaise, whatever the case may be. It's the same thing here. So now we say signature package. And then you can remove things. So on that sign it says, look, if you want this, but you can say each additional prayer card in bulks of 25 or 50 or whatever is going to cost you this. Extra hearse is plus this. Extra limo is going to cost you this. Now, why would you need an extra hearse? Well, maybe we had one service for multiple family members. That happens, right? So maybe we're kind of grouping things together, and now we're charging them for extra caskets, but we're only charging them for one funeral, one service, one calling hours, one all of that. So we can give them a visual of that. We're adding on hearses, we're adding on embalmings, things like that. So we can just say things like that. But in those cases, itemize it. It's much easier. Because if you did, it come up same price. But it gives them a visualization of what they're looking at. And then what you're doing is they're looking, saying, we want 2 limos. Okay, $480. They saw it right on the thing. They know what they're getting. But it's simpler to say everything's here, and then I'm just adding that ingredient. But they also know if they turned around and they said, I don't want a limo, we're going to drive all of our own personal vehicles. They also know that a limo costs $480 to rent. Therefore, this is negative $480 off of that. So signature package, negative $480, no limo. Okay. So that is how that works. Again, families really do like that. Your GPL, again, you have your itemized item, but then also put in all those, however you want to do that, you can put the packages in there. You can also have packages that do fall aside from those, where you do have for children a package for military, a package for whatever. For the children, we obviously have children caskets, infant caskets, or urns, things like that. Maybe there's some other child-related things that you decide that your funeral home is going to provide. A nice service that you do for children that was very, very touching. Maybe you want to throw in grief counseling as part of that for children. That's hard. Therefore, your funeral home does have a grief therapist on staff that does grief therapy. Does a group once a month or whatever, once a week, and depending on the need, and provides this group, and people meet in the parlor, and they do this. Or maybe you have a side room that's not really parlorish that they can meet in. Side arrangement room, a large arrangement room. So maybe you put that in there. That's part of your package, that you add that. Now, for you, that's a nice service. For them, that's a really touching service. For you, that's also a marketing thing. By the way, this is me stepping away from legal, but this is a marketing aspect to get you thinking and saying, these people are not just coming here every 13 years for a funeral. I have people coming back and being a part of the funeral home on a more regular basis. They get to know the funeral home. They get comfortable with the funeral home. And when they have to choose a funeral home, they recommend your funeral home to others, because it's not just like, oh, well, this is where we went. No, they have a personal relationship with the funeral home. So just something to throw out there. Military, something just to get your gears moving. Something you could put on there in a package would be, again, a flag case that you put on there, that you say, all the military, when you give them the flag, there's a flag case that comes with it, and that's our military package. Includes that in addition. It's just a nice honor that you as a funeral home provide to the military, and maybe it doesn't cost any more than anything else, but it's the military package. Maybe it includes some other items that you do. Right. Right. So again, disclaimers, warranties, all of that, you do need to have those listed properly on that. Right. So then we're still staying on the topic of who has the right of disposition. So in this case, right of priority does go to this is the ironclad, these are actual legal words, the ironclad rule of who has the paramount right of disposition. Okay? That there's no ironclad. Okay? In most states, there is no ironclad rule. Some states do, but most states have no ironclad rule. So it gets this kind of free-for-all. So now, as a funeral director, this does make you, it can make it very hard on you. So you could have, again, we know the next again, spouse is not next of kin. So you have spouse, then next of kin. Okay, that's how it's legally. Spouse, then next of kin. But you have circumstances where the spouse is estranged and the spouse is not available. Or the person, now you're trying to figure out, now go through this list. So the spouse, there's no spouse, it goes to children. Not adult children, it goes to children. Okay, just minor children can't sign, but it goes to children. If they have no children, if they do have children, side note is that the guardian of the children would sign on behalf of my child, so-and-so. Then to put the child's name. But if there's no spouse, there's no children, then it goes to a parent. If there's no parent, it goes to a sibling. If there's no sibling, it goes to an aunt. If there's no aunt, it goes to their nieces and nephews. So, okay. If it doesn't, then it can start going to like cousins and things like that. Be aware that some states, that it's legal for same-sex relationships, and some states it is not. So therefore you have to know the state that you're in and what the legalities are for that. It doesn't mean you can't give somebody rights. It just means that somebody else has to sign the paperwork. It does mean that you might have a legal issue if somebody else disagrees, the person signing disagrees with what their partner wants. But at the end of the day, it's best to kind of mediate that and give that partner the rights that they should have. Give them the ability. They are, it is the nice thing to do, is provide them the ability, but then have the person that has to sign. Right? And sometimes it's nice to have, in a circumstance like that, is have them sign too. Have the person that has to sign, and have the other person sign next to that. Give them the ability to sign. Give them the ability to have a voice and have their name on paper. Even though they're not the legal name on paperwork, give them the ability to be a part of that. That's important. Okay. But again, that could, change the court system, could change anything. The court system can determine really whatever they want. And again, at the end of the day, it does come down to the wishes of the decedent. What we should be doing, anybody signing should not be doing their wishes, even though that we know that's how it plays out. The person signing should be doing the wishes of the decedent. They should be deciding what that decedent would want in the best interest of the decedent. When somebody signs on behalf of a minor child, they are signing in the best interest of that minor child, and under the circumstances that what would that minor child want as the best wishes for the decedent. Okay, so you have to keep that in mind as to how that plays out as well. All right, so giving you another legal case here. I'm just going to read. So in this, the form of the preference is usually not important to the court. In other words, whether the preference was made orally or in writing is not decisive. While some courts will attach special significance to a preference written in a will, most courts do not. Okay, so something very important to know. Of course, the courts will balance the decedent's preference against the contrary wishes of other relatives. Certainly, most problematical case is when the decedent's preferences are not in accord with the surviving spouses. Jurisdictions are fairly split on this issue, with some courts following the deceased's wishes and others holding that the surviving spouse's rights cannot be defeated. Often, in deciding this issue, courts will look to see whether there was an estrangement between the couple prior to death. Okay, so that's important to know. In balancing the deceased's preferences against that of the next of kin, some courts tend to be more willing to side with the decedent's preferences. For example, I'm going to give you a legal case. Shea versus Duke University. Okay? The children of the deceased wish to have the body cremated, right? So we just went over this. Right? So that legal case did play out. Right? So again, that played out as to how that the writing in the will did play a role in that. Now, special relationships can also play a role here, so I'm going to read this. Another factor courts will examine is whether there are any special relationships between relatives of the decedent. Factors such as living under the same roof, financial support, or a special intimacy between the decedent and a relative may persuade the court to grant that relative the right of disposition. So, let's say a child may have a parent. The child dies, they may have a parent. But the parent is in and out of rehab, the parent is in jail. The parent, or maybe the parent is there, but the parent really hasn't been a part of that child's life. The parent is just doing their own thing, living their own life, and they have really no, and they don't have any significant involvement in that child's life, even though they may live under the same roof. But the grandparent or the aunt of that child was the one financially supporting them. The aunt or the grandparent of that child, or uncle, so aunt or uncle or grandparent of that child was the one really making sure they were fed, clothed, giving them the roof, taking care of them, things like that. Theoretically, this could go to a neighbor. This could be a situation where a neighbor's always taking care of this kid, and the parents, not really. The parents like comes and goes. The parent shows up when they want to, and this kid's left locking. What we call a turnkey child, and the neighbor ends up taking care of them. We've had cases where teachers take care of kids. I think that should be the circumstance for me in many cases for some of the students, where I could probably claim rights to some of the things I've done. Some of the financial support or you know, help that I've given. Right? Do you think that's the case? Yeah. So being able to step up and say, hey, this parent is not there in the court of law, somebody could fight. Somebody could fight for that, and could win in the court of law. Okay. So, so again, there's certain circumstances in that, right? In different states too. Do read up on. You do want to know about the anatomical gift law. Again, you should never try to convince a family. Otherwise, you're right to we embalm whatever comes through the door, and make sure that this is to be able to donate organs and tissue and all of that is a beautiful thing that saves lives and improves people's lives. And if you needed organs or tissue, or if your loved one needed organs and tissue, I know that you would want them to get that. So it's vital that we encourage families to consider the Anatomical Gift Act, and that is not skewed from that. All right. So where do you come down to? What are your statutory duties as a funeral director? First, you have to worry about permits, right? So things like that. You have to have the proper permits from the proper authorities for disposition or anything like that. And that also, not that the health departments look through things, because a lot of times they do. They get the job. They don't really know what it is that they're supposed to be looking for on the burial permit. They might just sign off. But I know they do question these things. So they do catch something. They may question something out of the ordinary. Not that happens too often, but their whole plan is that they're supposed to look down and say, why is this person being disposed of a place that is not a traditional cemetery? Maybe we need to look into this. Hey, that person died of an infection control case. Maybe we need to consult the CDC and say, is this a proper disposition? And that's a checks and balance system to ensure that things are being properly, taken care of. I'm going to give you a legal case. Right. So state and municipal statutes and regulations which require these permits have been upheld by courts as reasonable exercises by the state of its police power to protect the health of the public. Okay, as I just said. Myers versus Clark. This took place in Kentucky in 1906. So, a couple years ago. The court found that a regulation of the Municipal Department of Health requiring a burial permit to be issued before a decedent could be interred was a reasonable measure to prevent the spread of contagious diseases in the city and to protect the general health of inhabitants. You now know where burial permits came from. Okay? So now that is the origin of why those burial permits are so important. Okay? Other states have adopted that, and we are at the day that we are at today. Can think that we've done that since 1906. So it's very, very important. But at that time in 1906, they recognized that there was problems with disposing of infectious bodies and other health concerns that could come, with that disposition, right? So you do have a lot of other health things like that. So now, these are key words. The next piece I'm going to talk about are contractual obligations that you have to the decedent, to the public, and to the families that you serve. These are key words that you're going to need to know, because these are the key things that come back, that when there's a lawsuit, these are the key things that you're going to be sued for. Number one, negligent embalming. Okay? So, when a funeral director contracts to embalm a body, he or she undertakes the use of the skill and care of a reasonably prudent and careful individually skilled in the art of embalming. So basically, by embalming, you're saying, I have the skills to do this. When the family contracts with you, they're saying that my loved one is going to be embalmed by someone that knows what the heck they're doing. Right? I'm not contracting to say, I taught my kid how to embalm. 12 years old, he can do that. Right? He may be a great embalmer, but he's not licensed to do it, nor did he go to school for it. But, not meaning that we can't teach people, but at the end of the day, that also means that if your trade embalmer is not good at embalming, they're not the best embalmer you've ever seen, fire them. Fire them. Get rid of them. Okay? Because if they're not doing their job, if any embalmer, any embalmer under your roof, okay, is not doing the job, fire them. They are not an embalmer. They are a fluid pusher, but they're not an embalmer. Okay? You should only be getting good work, because you're opening yourself to lawsuits if you do not. Okay? I don't care how long you guys have been friends. They do not. If anybody that is embalming should be the best embalmer you've ever seen, and there should not be issues after they're done embalming that body. That body should be perfect. Right? What does that do? If they know that you're going to threaten to fire them, they're going to learn how to embalm. They're going to take their time. They're not going to pride themselves on how quickly they can do it. They're not going to do a half-assed job and just put fluid in and leave. They're going to take the time to make that body presentable. They're going to make that body preserved. And they're going to make that body not a sanitary hazard. Okay? So in embalming, we mentioned that there's 3 purposes to embalming. And yes, they are in this order. The primary purpose of embalming is to secure the public's health. It is not preservation, and it is not returning you to a lifelike form. It is preserving. It is securing the public's health. That is the key purpose of embalming. Next is preservation. Third is returning somebody to a presentable appearance. Okay, but the primary purpose of embalming is to secure the public's health. Okay. So, in this case, we have Thompson versus Duncan Brothers Funeral Homes. This took place in New York State. The casket was opened for the family, and the remains were found to be decomposed, swollen, and odoriferous, and leaking fluid. The court awarded members of the family $35,000 to compensate them for the personal injuries they suffered upon witnessing the results of negligent embalming. Okay, so this is a punitive damage. Punitive damage means that the family did not lose money off of seeing this body, but they did have mental anguish. That was negligent embalming. That body should have been in a presentable form. That body should not be odoriferous, okay, or leaking, okay, or swollen or decomposing. That body was negligent embalming. And because of that, that funeral home is liable for that. And and they got punitive. They had to pay out $35,000 for punitive damage. All right. In California, a funeral home was held liable for an alleged negligent embalming of the plaintiff's father. In this case, the decedent's body was shipped from California to Oklahoma. Upon arrival in Oklahoma, the body was in a decayed condition, malodorous and dripping fluid. The court held that the mental and emotional shock suffered by the plaintiffs upon learning that the body was in such a condition made them ill, and was an element of compensable injury. Okay, so if you're looking that up, that is Carney versus Lima, Salmon versus Tully Mortuary. So there's two cases there. That's one case. Sorry, I read that wrong. Carney versus Lima, Salmon, and Tully Mortuary. That's the name of the funeral home. So, again, this is a problem. Then we have cases of negligent funeral directing. The failure of a funeral director to perform the many duties involved in directing the funeral service will give to liability. So now we look at the case of Golston versus Lincoln Cemetery Incorporated. This took place in 1978. A funeral director who had failed to properly supervise the burial at the cemetery, thereby permitting the decedent to be buried in a shallow grave and without the vault that the contract provided for, was held liable for breach of contract. The court not only awarded damages for mental anguish suffered by the family, but also imposed punitive damages against the funeral director. Alright, that's a problem. Right, and I always tell you, watch that body go into the ground. Go into the vault. I want to see that lid go on. I want to see dirt get supported. Maybe I leave at that point, but I want to see. There's many cases. If this was my loved one, there's many times. I am a funeral director. You're not going to keep me away from that grave. Okay? Let the family go. But if this is colleagues, where I'm standing next to a colleague, I'd be there with a fellow funeral director if they were burying their loved one, and with their mother, their child, whatever. I've been there many times with a colleague, and I never left their side because I was like, I'm going to stand here and I'm going to also watch that vault get close to make sure that it's done properly. My own teacher, my high school teacher, was passed away recently. Very traumatic death. The funeral assistant for the funeral home was there. Stayed. The funeral assistants, they stayed. They all had the same van. So they stayed. And I stayed there too. The funeral directors all left, which was fine. And I stayed. Because I said, I'm going to make sure that this is done properly. Not that I don't trust the cemetery, but my own peace of mind. That was one of my favorite teachers in high school. I was there. Okay? So I'm going to make sure that it happens. And that's what you should do, because you don't want to have that come back and sue. I'm going to give you another case. Wilson versus Ferguson. This took place in 1988 in Texas. The facts show that when the funeral procession arrived for the graveside ceremony, the grave had not been properly prepared. Rather than assisting the family, the funeral home employees left the gravesite, saying that they were in a hurry for another funeral. When the body was later damaged at the cemetery, the court held that the funeral home had breached its contractual duty to perform its services with ordinary care. Always drive by a cemetery, always make sure there's a hole in the ground, make sure the vault is in that hole. Okay, if you have to do above ground vaulting, that's fine, but make sure that that's happening. I'm going to make sure that that vault goes into the ground. I'm going to make sure that if there's usually above ground vaulting means there's water table is up to the thing. If you looked at that hole, it's like a pool. It's filled with water. So cases like that, I'm going to make sure that that vault is in. I'm going to make sure that the dirt is on there. I'm going to make sure that that vault is right side up and not upside down when it happened. If anything happens, I'm going to be there to make sure it doesn't happen wrong, and that it's fixed if it does happen. Lamb versus Shingleton. This happened in North Carolina in 1949. A funeral director was held liable for the mental distress suffered by a surviving spouse upon learning that mud and water had entered the vault containing her husband's casket. The vault had leaked because the funeral director had failed to lock the vault properly. Well, that's a problem. All right, Clark versus Smith. This happened in 1973 in Texas. The employee of the defendant was instructed by the plaintiffs to hold the dead body until they decided that what funeral director to call. Okay. When the defendant had possession of the body, it underwent drastic putrefactive changes. Although the defendant was never instructed to embalm the body, there was explicit testimony that he should take the body and keep it in a suitable condition pending burial. I mentioned that earlier, didn't I? The plaintiffs brought suit for mental anguish. Again, key word. Okay, we hear this a lot in funeral service. Mental anguish. Mental anguish suffered at the appearance of the decedent as a result of the defendant's negligence. Okay, most legal cases we have fall under negligence. You didn't do your job. Okay. Most people don't sue because you did too much of a job. They sue because you didn't do your job. In not keeping the body suitable for burial. In not using preservative fluids. In not refrigerating the body in order to preserve it. And in not informing the plaintiffs as to what was necessary to preserve the body to keep it suitable for a decent burial. All of which were proximate causes of plaintiff's mental anguish. The court held that the above allegations constituted negligent breaches of a duty owed by the funeral director to the decedent's family. Okay, and again, this is the kind of thing that if you go to court, your attorney, and so is the plaintiff's attorney, they're going to be pulling the legal cases that I'm talking about right now. If you go to court, the same things I'm reading to you are what they're going to tell the judge, and they're going to say, in Clark versus Smith, 494 SW2D 192, Texas in 1973, this was the verdict, this is what I want, this is what happens, and the funeral home does wrong, done. Guess what? Close case. That is a close case. As soon as they say case law, as soon as they say this happened before and the court says it, close case. You are screwed. Okay? So don't do it in the first place. Don't do it. Okay? All right. Here's another one. Funeral directors may also be liable for failure to honor requests made by the family. For an example, Mayer versus Nodger. This took place in Iowa in 1976. Now, there is a lot of court cases that have taken place recently as well. You have to keep in mind that the book that I'm reading from was published a while ago. So keep in mind that the court cases are all going to be a while ago. And a lot of times these court cases are not going to come out because they were good examples. They were a lot of times the original example. And therefore, by being the original example, all of the court cases that came after them are using them as the precedent. So these are the court cases that set precedent in the court of law. Right. But there are, if you look at more modern textbooks, there are more modern cases that took place, and you'll find those as well. But these are very relative, and again, these are the precedent that has been set. The complaint alleged, complaint alleged, among other things, that the funeral director had improperly refused to allow the plaintiffs to view the body and had failed to comply with his agreement to delay the funeral procession until the plaintiffs could arrive at the funeral. We do have a lot of people that travel, right? We're a very, world that moves all over the place. Think about where your relatives are. They have to fly in and things like that. As a result, the plaintiffs were unable to attend the burial, which they alleged resulted in mental anguish. And in one case, a heart attack. Somebody actually the stress gave them a heart attack, a myocardial infarction. Yikes. Right? Yikes. Okay, so now we have medical. Once you put on the books in the court of law that somebody suffered something medical, that's not going to look good for you. Okay, that's why everyone that had a fender bender shows up with a neck collar to court. Do they need it? No. Okay, but their ambulance chasing attorney made them wear it. But in this case, the person had a heart attack. There's a medical. This is not just saying I'm wearing a neck collar to court because my ambulance chasing attorney told me to. The person has medical documentation that they actually had a heart attack. That's on a monitor. That they actually have treatments for that. That's not going to look good for you. Right? The court found that these allegations were legally sufficient to allow a jury to decide the case. Geez, they had a jury. Okay? This didn't just get settled in court. This went to a jury. That says something about the case. Alright? Further on. So, substantially, liability can be imposed for what appears to be minor errors of judgment. In a recent Washington case, the surviving spouse had requested that her husband be buried wearing his favorite cowboy hat. When the funeral director returned the hat to a different relative rather than complying with the request, the jury awarded the spouse $100,000. Yikes. Okay? Yikes. Alright? They better be burying me in my boots, by the way. Unless somebody wants them. Maybe that goes to the highest bidder. Alright. Safeguarding the body. Although cases of mental deranged people sexually assaulting or harming bodies are rare occurrences, a funeral home may be liable for such general unforeseen occurrences if it does not reasonably precaution to safeguard the body. Okay, this happens a lot. Okay, be amazed that this happens a lot. We don't talk about it a lot. Our funeral handbook has a necrophilia clause in it for a reason. But something like this does occur to the point that you may not think about it. Now, here's the precedent. You go to court because you did not safeguard the body. So in this case, somebody breaks into the parlor and they molest or rape the decedent. And all of a sudden you say, I didn't know that would have happened. And the court, your other attorney is going to turn, the prosecuting attorney is going to turn and say, did you not read your mortuary law book? Did you not hear that in class? They said, and you turn and go, well, no, I didn't learn that. And they're going to turn and they say, well, what was your textbook? They're going to turn in and say, well, according to Gilligan, page 26, I hold the book in my hand. And on page 26, right here, it states that you must safeguard a body. And in safeguarding the bodies may be molested or raped. Did you not know that a body could be raped? Did you not think about the safeguarding a body? Did you not think that you should make sure bodies are properly taken care of and safeguarded, that things could happen to a body? So, that would be an issue, right? So what I usually say, and I've always said this, is I worked for a funeral home that had 4 parlors. You came in, the hallway was shaped like an X or a cross, however you want to picture that. So you came in, and I worked for many funeral homes. I worked for nine funeral homes that I worked for over the years. And but one of those homes, so it was a nice cross. It was one of the places I worked the longest, and it had a cross-shaped hallway, offices, garage, bathrooms, other arranged room / parlor. But then this hallway went, and you had doors across from each other, 4 doors. 2 across from each other, like that. And you straight across, you had your, the back side of one of those parlors, straight ahead. If you come through the back door, straight ahead, there was a door that could go through and give you access to the back side of the parlors on that side. Now, of course, there's a room divider. So normally we have 2 parlors where you typically used one of those parlors. So we typically had these 2, the divider open, we had chairs going all the way back, we had a full big room, but in the circumstance that we needed 4 rooms, we had the ability to close that off. We had the ability to have 2 rooms on each side, rather than 2 larger rooms. We had 2 rooms on each side, and we would have the ability to or store things in one room. So what we did was we usually left that side open. Now, we never had a problem with safeguarding. But on that side, we leave that open. Now, that meant I had the other side. The other side didn't have a back door. It had 2 doors. It had the divider that went between them. So what we would do is I would put all of the bodies that were ready for cremation I would put all of the casketed bodies that were ready to go into the parlor. So as soon as we move this casket out, before the funeral assistants go back out to their cars, I have the funeral assistants or myself, as they move them out, I go, okay, we're going to move this casket over, and that casket gets put into place. Then we have, as we're gone, we have funeral assistants, apprentice, whatever, putting flowers out for the calling hours that are going to take place, or whatever the case may be, or if the flowers are arriving. But we at least move the casket over, and we had it in place. We moved it onto the beer, or in other words, moved it off the church truck onto the beer. But all that body was stored in the other parlor, which is pretty stereotypical. This is normal for a funeral home to do. But because I had 2 doors, what I did was the parlor that I put them in, neither of those doors had a lock on them. You couldn't lock the parlors. So I put them in, I took a door stop, I took multiple door stops, not one, and I kicked them under. So now both doors, you would open one door in order to unlatch the other one to open, but it was double doors. But what I would do is I took that and I'd put multiple door stops in, I'd just kick them under the door from the inside. And that meant that, could you push hard enough and open it? Absolutely. But it would take some effort to push it, which means we could stop somebody from opening the door. We would notice that somebody was opening the door. They couldn't just quickly open it and walk in. Then what I would do is I would position I would close the divider between. Then I would position somebody in front of the doors, the rear doors, like a funeral assistant or somebody would be positioned there to direct traffic. But because they were directing traffic and saying, oh, register, did you sign the register book? And it's across from them, rather than there, they were blocking that door. Which means that nobody could go through that, and that door couldn't lock because I needed to be able to get in there to get the bodies. But that door was blocked. And that was considered safeguarding the bodies. Safeguarding also means having a lock on your prep room. I've walked into numerous rooms, I've worked for numerous rooms, there's one key, it goes to everything. It goes to the prep room, it goes to the funeral home, it sometimes goes to the apartments above that are not occupied by people from the funeral home. Okay, it's a different key. Or it's just the same key, rather. That's a problem. Okay? They should be separate keys. Your funeral home, you have a lot of assistants, you have a lot of people coming in and out. Maybe you have somebody that's cleaning, you have the, maid services that are coming in, cleaning services that are coming in. Those people do not belong in your prep room. And the people from the apartments above do not belong in your funeral home or your prep room. So, I've worked for funeral homes where the person living above in the apartment got arrested for dealing drugs out of the funeral home. Okay, not saying that that's a precedent for things, but obviously you have something going on there where maybe we could be stealing money from the cash, from the office because we need drug money. Or I'm just speculating here, but you have to consider these things. So safeguarding your money too. Now, whether it be molestation or rape, and it does happen, people do sneak into other parlors. They will do things, pretty nasty things to bodies. The other thing you have to safeguard bodies from is theft. And you're like, people would steal a dead body? Yes. People steal dead bodies. We had a case, not we as in something I was involved in, but there was a case where, many cases, this has happened frequently, where there was custody disputes. And the person has gone nuts after the death of their daughter, child, whatever, where they were not allowed to have custody of the child. And they said, well, if I couldn't have custody of him in life, I'm taking him in death. And they went in. Or they couldn't decide over who was going to have the rights of disposition between 2 parents. Both parents had rights. And one of the parents goes in, breaks into the funeral home, steals the body, and runs off with it. Okay? Like, somebody would do that? Yes, they would do that. They're not robbing the money, they're taking the body. There was a circumstance where somebody broke in to a funeral home. Get this. They broke into the funeral home. Now, the person goes to court. The funeral home says, hey, this is, basically it was like, hey, the person literally broke it's not like we left the door open, it's not like we left the door unlocked, it's not like we didn't safeguard the body, we had a lock on the door, we had all of these things, the body was in the parlor, the person came in and molested the body, they stole the body. We've had multiple cases like this, where people broke into the funeral home and forcefully broke into the funeral home to do this. And at least in one of these cases that I know about, the court ruled in the person's favor, not the funeral home's favor. Because the funeral home did not install locks that were not pickable. They did not have locks that were not able to be broken into. Seriously? Seriously? The court ruled in their favor because their locks were not unpickable. Okay? That says something for our legal system, but just something to consider. Okay? How this plays out. Let me give you a case. Draper Mortuary versus Superior Court. Okay, so in a case like this, obviously, this is against the court. This is going to the Superior Court and something like this. This did happen in 1982. A person entered through an unlocked chapel door and sexually assaulted the body, which was lying in state. Although the defendant claimed there was no history of such prior occurrences, which would have forewarned him to take safeguards against such intrusions, the court rejected that defense and found the funeral home liable for violating its special duty of care that exists between a mortuary and a bereaved family who leaves their remains of their loved one in the care or the custody of the funeral home. This means lock your doors, people. Okay? The funeral home door should never, ever, under any circumstance, be unlocked unless you have people safeguarding those bodies. If it's during calling hours, during a funeral, the door's unlocked. But otherwise, those doors should be locked. When somebody comes for arrangements, they're coming to a locked door. Unless you have a receptionist. I've walked to funeral homes where there's a receptionist there's a counter. Let's say you walk into a hotel. It's beautiful. They come in, there's a receptionist. You come in, you talk to the receptionist. It's basically the funeral home office. The person's standing there in that, looks like a hotel desk. And the door's unlocked. You come into a lobby, fountains, statues, everything. The Greek statues are beautiful, absolutely beautiful. But that's fine, okay? But you should have a lock. And what happens if that person steps away from their desk? They have to go to the bathroom or something. You either lock the door, but those parlors should be locked in some way to safeguard all of those bodies to make sure that they're taken care of. We also have cases with privacy. So, again, you have to be wary of families that call. Somebody calls, they say, oh, I'm the aunt. Oh, no problem, I'll give you information about that service. What's the cause of death? What are the services? People call and they will ask just about any question. So you have to fulfill requests. You cannot just give out information. That's very important. Okay, so if the funeral directors fail to comply with the survivor's request for confidentiality regarding the death or for privacy during the funeral arrangements, they can be held liable for such breach. That's a breach of contract. That's the key thing. That's a breach of contract. So Fitzsimmons versus Ullinger Mortuary Association. This happened in Colorado in 1932. A funeral director was requested to transport a body and prepare it for burial without any undue publicity. When the funeral director photographed the body and used it in... Holy shit. When the funeral director photographed the body and used it in advertisement... Please don't do this, folks. Please don't do this. The court held that the funeral director had violated the expressed and implied promise not to violate the confidentiality of the family. Okay, confidentiality and privacy goes just not even answering questions on the phone. You don't tell people when services are unless it's a public service and it's published. You definitely never tell anybody the cause of death. But definitely do not photograph a body and don't photograph that body and don't publish that. The fact that the court found a violation of an implied promise suggests that the funeral director would have been liable for violating the confidentiality of the family, even had the family not requested that the funeral director avoid any undue publicity. Obviously. Okay, so even if the family didn't say anything bad about it, the family could have all, oh, that's cool, my mother was in the newspaper, look at that, oh, my mom's dead body was on a poster board. And the family could be cool with that. Oh, that was a good last wish. That's still a violation, okay? The court can still bring you to court over the fact that you were stupid enough to do that. Right. The courts have also upheld a family's right to request a cemetery and presumably a funeral director to exclude unwanted visitors from a funeral or burial. We've talked about this, right? We talked about Ross versus the Forest Lawn Park. We talked about that. So again, that falls under privacy as well. Now we get into something like defective merchandise. Now, when you sell merchandise from your funeral home, you are promising that family that what they're getting is not going to be scratched, dented, the hinges are not going to be broken, all of that. You're providing them good merchandise. And you inspect it when it comes from the casket company, whatever, you're inspecting that and saying, yes, I got good merchandise, or no, I'm not, I'm going to send that back, or, hey, you need to bring me a new casket that's not scratched. You should be inspecting that. Now, you may turn to the family and say, look, the casket arrived, there's going to be a little delay for that casket, the new casket to arrive. Here's your options. Would you like the services to be delayed by a day or two so that we can get a new casket or an urn? Would you like this defective urn or this defective, and I will take money off for it because it's not your fault, the scratches on the back side of the casket, here you go. Now, if it's under where the apron goes, nobody may even notice, but I might want to tell the family and say, look, when we remove this, nobody's ever going to see it during the service. The scratch is there. When I remove this, no one's ever going to see it. When we go close the gas, no one's ever going to see it. The family's going to go, that's fine. Or you might get a family, I want this to be my way. Okay. That's however you want to do that, okay? But in this case, can families provide their own merchandise? Yes. Okay, they can bring their own urn in, you bring it in, I fill the urn, perfectly fine, no questions asked, okay? You gave me something, I fill it for free, I give you back that urn. If somebody has a casket, those are not usually hand delivered. The casket could show up in someone's pickup truck. I've had that happen where they showed up, they bought a casket, and they showed up with the casket in the back of a pickup truck. I unloaded it, I inspected that, I said, look, there's a scratch. Can we, we're like going through your rental car, I went around and took pictures and said, we're going to acknowledge that, can you please sign that acknowledges, I write up and just said there's scratches on this, I put it on paper and they signed it saying, yes, they acknowledge that there were scratches on that casket. You can have them sign that says, I'm not responsible for the quality of merchandise that you buy. Can I charge them extra to accept that merchandise? No. Okay? But I have to accept it, but it is okay to have them sign saying that you accept that there's defects. All right. So in this case, you do make warranties and all of that. So in this case, let's give you an example. We have a State of Harper versus Orlando funeral home. This took place in Florida in 1979. A funeral director was held to have breached an implied warranty of merchandisability and fitness for particular purpose when a casket holding the body fell apart as it was being transported to the grave. Well, that is a problem, right? You have defective merchandise. The bottom of the casket does fall off. We've had this happen. Wooden caskets, the person is leaking, they're soggy, it deteriorates the bottom of the casket. Now you have not just defective merchandise, but you have negligent embalming as well for the fact that that person was leaking. No body should ever leak under any circumstance. And because of that, that body is degrading that casket. You lift up the casket, the person stayed in the church truck or the beer, or you're carrying them up the church stairs and boom, the person falls out. I know we see this in comedies, we see this in movies, it really does happen. So that's a problem. Okay. McDaniel versus Bass Smith Funeral Home. This took place in 1986 in, I believe, North Carolina. A funeral home was found liable for supplying a casket that would not close properly. The evidence of the unworkmanship-like conditions was supposed by findings that the defendant's employees experienced difficulty closing the casket before funeral service and that one corner of the casket was not closed during the services, thereby allowing the decedent's remains to be visible. The court allowed the plaintiff to recover for emotional anguish under these facts. Alright, so in Contom versus McGuire Funeral Services, this took place in D.C. in 1970. A handle fell off of a casket while it was being carried by a pallbearer. He was injured as a result and sued the funeral director, alleging that the casket was defective. the lower court dismissed the complaint because it found that the pallbearer was not the intended user of the product, and therefore the funeral director owed him no duty of care to provide a safe product. Well, that's interesting. The appellate court reversed, however, and held that the pallbearer was indeed the intended user of the casket. The funeral director was held liable for supplying a defective product which violated the implied warranties of merchandisability and fitness of particular particular product or purpose. I would love to know, I would have wanted to fly on the wall in the first court where they had to look and say, sorry that they were not the intended. Okay, intended use, yes, is for the decedent. Okay, so on a technicality, the decedent is the intended user of the casket. I would love to know how that defense went through, that the decedent was. But however, my question on this is, the deceased cannot carry their own casket. So the intended user of the handle, the product of the casket that did not work, was the pallbearer. So I would have loved to know how they got that first case fought, saying that they were not the intended user. Right. Other things that we have to consider is transportation. So in this case, we have the funeral home supplies the limo and the hearse, the limousine and the hearse. Now, in this case, we could use the funeral home supply vehicles or a private service, which would be considered by legal terms, a private carrier. That's what that's considered, private carrier. So, in this case, they are charged with the legal duty to transport its passengers in a safe and non-negligent manner. If the funeral home fails to exercise ordinary care in carrying out the transportation and, as a result, therefore, a passenger is injured, the funeral home will be liable for breach of contract. Right? In order for the funeral home to be liable, it is necessary to show the negligent driver of the vehicle was an agent of the funeral home. Okay, so they cannot sue the funeral home unless you are an agent of the funeral home. What does that mean? That means that they're representing you. So, if you were to be an agent of the funeral home means they're representing you. If I were to go out on a removal, you were to call me, I have a minivan, I go out to you call and you say, I'm using Shea's livery service. Shea's livery service is licensed to do this, goes out, picks up somebody from from the home, from the nursing home, from the hospital, whatever, and transports that body back to the funeral home. If the funeral home says, I'm sending somebody from my funeral home to go there, and that person, when they arrive, says, I am from McDonald Funeral Home, I go there and I say, I'm from McDonald Funeral Home. I do not say I'm from Shea's Livery Service. And I will bring them back. But I am from McDonald Funeral Home. I am representing myself as McDonald Funeral Home. Therefore, they are an agent of the funeral home. If you, as the funeral director, hire a livery company to provide hearses and limos for your funeral home, for the services, or removals or anything, but for the services, and during that service, something happens, they are an agent of the funeral home. That is how that legally works, an agent of the funeral home, because they are representing you. That family does not know otherwise. The family does not know that you don't have hearses or limos in your fleet, or enough in your fleet. As far as they're concerned, they hired you to have a service. You said you're providing hearses and limos, therefore you're providing hearses and limos. Those are your hearses and limos for the day, and therefore you're liable for anything that driver does, that agent driver, that's a term, the agent driver, or an agent of the funeral home, that limo and all of that is all under you. If something happens, you are legally responsible. Now, under that circumstance, you could have a person that is not an agent of that funeral home. I show up and I say, I'm Shea Transport Services, and I will be, they have hired me to come and get that. Well, I'm still an agent because you still hired me, right? You didn't show up yourself. You did not do that removal yourself. You are still responsible because I messed something up. You're liable for that. because you hired me. However, on the service, the family hires their own limo company, their own hearse company. They call the local livery company and they say, we would like three limos and a hearse to transport our loved one at this funeral home. You did not hire the livery company. They did. When that livery company messes up, that livery company is an agent of themselves. They represent themselves. When they mess up, they are responsible for their own problems, their own failures, because you did not hire them. What this means is that when you hire somebody, you should be only hiring people that are going to do a good job, are going to be good agents, they're good drivers, they're good everything, because they're representing you. But legally speaking, you're only responsible if you're the one that hired them. If the family hires them, then that company's responsible for itself. So just keep that in mind in transport. So in this case, we also have the driver is an employee of the funeral home, or if the funeral home engages with limousine service, as I said, they're owned by that. So you're responsible for the negligence of that. So here's the circumstance that goes along with that. Sack versus A.R. Nunn and Son. So this took place in 1934. A Supreme Court of Ohio held that the funeral director who had undertaken by contract to transport a family could not relieve himself from the negligence of the driver by showing that he engaged another to perform the transportation, especially when the family had no notice that the transportation service was being rendered by someone other than the funeral director or one under his control. Okay, so that's the wording that legally binds them. On the other hand, if there is no agency relationship between the driver and the other funeral director, liability will not be imposed. In Plantal versus Schreiber, also took place the same year. Or no, actually a couple years later. This took place in 1939. A volunteer driving his own vehicle in a funeral procession caused injury to his passengers due to negligence. The court relieved the funeral director from any liability because there was no showing that the negligent driver was under the control or direction of the funeral director. So someone brought their own limo, someone used their own vehicle. Now, could the funeral director be negligent? Yes, the funeral director could be negligent because he didn't warn families like, hey, you guys, you need to stay bumper to bumper. Don't hit the bumper in front of you. We need to stay close enough. If I stop at an intersection, then everyone stops. When I go through that intersection, do not stop for the red light. Continue. But if if the funeral director were to try to go through a green light or a yellow light, and said, look, I got 100 cars behind me, and I'm never going to make it, then he should be stopping at that green or yellow light, knowing he's not going to get that procession through. But if he goes through and he says, all right, and if you see that green light, that light's been green for a while, and you say, that's been green, I'm going to stop. But if you look and you're like, all right, the light had just, the light is still young, let me get through this procession, you can go through. But that procession doesn't get all the way through before it turns red. The people should know that they need to continue moving. If they see red, and as soon as a car stops, that car is no longer part of your procession. As soon as a car stops, they are legally part of your procession if they continue going. But as far as they need to know that once you stop at that red light, you are no longer part of our procession. You are now on your own, and everyone behind you is now on their own because you stopped. Because as soon as you stop, you've signaled to the cars on the other parts of the intersection that is now they're able to go. But if you stay bumper to bumper through that intersection and you continue moving, that light might turn green and red again, and those cars may not be able to go, and that's fine. But you've kept them going. As soon as a car stops, that car cannot go, because otherwise they're about to get T-boned, or someone's going to get T-boned when they try to continue through the intersection by doing that. So that's just very important things. But did you warn them? Did you identify your cars as part of a procession? If those cars are not properly identified, then then you try to get yourself out saying, look, I did everything I could to prevent that. Otherwise, you are getting a lawsuit. All right. Aftercare refers to grief counseling and things like that. You as the funeral processor, you can provide like group. You can have a grief group. You can run that. You cannot provide therapy. You cannot provide counseling, but you can provide grief groups and things like that. You can have ministers provide. You can have therapists come in. You can have a therapist provide therapy. You are allowed to do that. All right. Then we have something referred to as tort liability. Tort liability is wrongfully withholding a body, loss of a body, mutilation of that body, things like that. So that all falls under tort liability. So wrongfully withholding a body. This could say like, hey, I'm not going to bury this body or I'm not going to cremate him until you pay me. You again have the right, not the right, you have the duty and the obligation to properly dispose of bodies and properly hold bodies in your care in a proper state of not decomposing. Okay. Therefore, if you say I'm holding that, or I'm going to withhold cremated remains because you are withhold those cremated remains because I haven't paid. Well, I've seen my boss go to court over that, and he's like, all right, where's the cremated remains? And he brings them to court with him. And he's like, I will give you the cremated remains. But the court can also say you need to pay the bill. So yes, it can go to court over that and say, we'll do it. But no, you cannot withhold anything because they did not pay the bill. It doesn't work that way. If you lost a body, that's a big issue as well, obviously, right? So in that case, I'm going to give you... or let me give you a wrongfully withholding body legal case first. Okay, so in this case, we had Morgan versus Richmond. A funeral director who withheld the body of plaintiff's deceased mother until payment was made was liable for damages resulting from the humiliation, embarrassment, and mental distress suffered by the plaintiff. Okay, so those are the key things that they're going to bring you up on. That they're being humiliated, that they didn't pay their bill, things like that. Okay, now they should pay, but people didn't. Obviously, withholding a refrigerator or a television down at Sears that says like, hey, look, we're not going to give you this until you pay. Well, is that humiliation? No, you don't get a big screen TV unless you buy a big screen TV, right? That's a luxury item. Versus somebody didn't ask to die, so therefore they may not have the money to do that. So it's humiliating the person that they don't have the money to bury their loved one, is where they're going with that. Okay. Levite Undertakers versus Griggs. This was Alabama in 1986, where the court found that the refusal to release the body was morally reprehensible. Morally reprehensible. Okay, so you do not want your funeral home to be attributed to the words of morally reprehensible. Okay, not words you want to have attributed to your funeral home. All right, so loss of body. So in this case, I think it's pretty straightforward. We see misidentified bodies. The wrong body gets buried. The wrong body gets cremated. You've lost cremated remains. You don't know where the body went. You put it, we've had the wrong body. I've had the wrong body picked up from not me, but I went to a hospital to go pick up a body locally. Went in there, and I opened the fridge door for the person that, where my body should be, and there was a different decedent in there by a different name. Obviously by a different name. So then I looked at the drawer that had that decedent's name on it. I opened it, it was empty. I look in the logbook, and they had signed out that decedent. The decedent I'm looking at in the fridge was signed out in the logbook at the hospital morgue. Well, that is a problem. So I looked at the name, I looked at the funeral home name, I figured out who the funeral home was. I called the funeral home, and I spoke to the director, and I said, hey, look, I think you have my body. And he looks and he goes, you gotta be kidding me. I said, no, I think I looked at all the drawers, I looked at every one of them. They didn't mix up more than one. I think they put your body in my drawer and my body in yours. It got a lot of swearing because the person that did the removal was the funeral director's son. The funeral director used a lot of profanity on how his son was going to drive that body up to me, and it was a good drive, and it cost money. So I basically said, well, would you like me to take your body into my care? I'll sign out your body, not a problem. I sign out your body. I'll bring it back to the funeral home, and then your son can come to the funeral home and can make the exchange. And he goes, absolutely not. Leave that body in the hospital. He says, my son will personally come up and deliver your body to your funeral home, and then we'll go to the hospital and we'll get the proper body and sign that body out. I said, I appreciate that. Not a problem. So he did that. But that's concerning, right? We've lost a body. Now, all right, so in this case, we've had a lot of misidentified bodies, things like that. They've been interred. So here's our legal cases that go with this. We have Holson versus Heritage Mutual Insurance Company. So now they're suing a insurance company. All right. This happened in 1991. The funeral home had mixed up two bodies and had the plaintiff's father wrongfully interred. When the body was not available for visitation, the court found that the funeral home had negligently interfered with the family's common law right to properly conduct a funeral. So we'll come back to the word common law. Right? I had one where, again, I worked for somebody I didn't really care for. So, he had he had the right to seat in the casket, but he had put the wrong photo on the foot end of the casket. So the family comes to down to the parlor, and the family goes, that's not my father. I'm like, oh shit. I'm like, this is not good. He goes, that's not my father. Now you realize the prep room that I was doing the embalmings, he was handling those. I handled the embalmings. I was embalming at a location that was the other end of the city, the other end of the town. So to swap out the bodies, if there was wrong, would have been a problem. So, they said, that's not my father. I'm like, you gotta be kidding me. I'm like, I put the right bodies in the right caskets. If he put the wrong body in the front of the parlor, that was on him, that was not on me for grabbing the wrong body. So I go up, he's got all the big bosses are sitting in the office, he's mooching and smooching and brown nosing and all of that to them. And I put a big smile on my face as I walked in, and I said, or they did, I said, well, all right, let me think. And I found out that it was the photo. It was the photo on the foot end of the casket with the right body, but the photo on the foot end of the casket was the wrong photo. It was not their father in the photo. Whew, I can fix that. So I go up, he's talking to the big bosses, and because I needed to give him a little bit of a, for what he did. I said, they said that's not their father. And I had a good laugh on the inside, and I kept a serious demeanor, and he goes, and I'm like, and I had the photo in my hand. And I said, they said, let him panic for a second, and they said you put the wrong photo on the casket, and I handed him a photo. I said, I need the right photo to go on that casket. I just said it nice way, I just need the right photo to go on the casket. I did right in front of the bosses so that they would know that this is not something we do. We double check. First of all, I don't know how you put a photo on the foot end of a casket for the wrong deceased when the deceased is literally sitting right there and you can see that that is not the same person as that. So, I don't know. But, could that have gone wrong? Yes. Something like that can go wrong. So we do want to make sure that. All right. Mutilation of a body. Now, I'm going to remind you that all embalming is defined as mutilation according to the court of law, which means if you do anything wrong, you're already conducted mutilation. By definition, the family can say you conducted mutilation. If you embalm and you do not have permission to embalm, you mutilated a body. If you do something outside your scope of practice, you mutilated a body. If you provide restorative art skills and you did not have permission to do restorative art, you mutilated a body. So everything has to stay within your scope of practice. All right. So in this case, the purpose of burial carries with it the right to receive a body in a condition it was in at the time of death. Well, that body looked pretty bad at the time of death, but if I take that body and I leave it as is, and it doesn't decompose more, I'm good. So if I can leave that body, that's the definition right there. So the thing is, you're looking, well, I can't make that body look good. You don't have to. But if you can prevent that body from getting worse than it already is, you have done your job within your scope of practice. Okay? So use that word, that definition legitimately there. If the body was mutilated, a tort has been committed. All right. So, again, mutilation can be slight or intentional and all of that. So, generally, the funeral director has the right to do this, referring to embalming, as the mutilation is implicably sanctioned by the permission given to embalm the body. The family signed and said, yes, they didn't say you can mutilate my body, my loved one's body, but they gave you permission to embalm. The same way surgery is also considered mutilation. But when you went to the OR, you gave that doctor directions to and permission to mutilate your body in the name of keeping you alive and well. Okay? All right. So, if, however, the embalming is done without permission, a tort of mutilation of that body occurs. All right. So, Sikorsky versus Simmons. This took place in 1940. A funeral director received an unidentified body from a coroner who advised him to embalm the body. The funeral director followed that advice and embalmed the body before the next of kin could be located. We do have a lot of issues with coroners and coroner-based systems, by the way. There's a lot of legalities that come up. Now, I'm saying all coroners. We have some excellent coroners out there. We have some great coroners out there. But it's like one of those things when you're looking at legal systems, you're like, where do we see the most issues? Where do most scandals take place? Cremation is usually involved in the scandal. Why? Because we're seeing a lot of people giving back concrete and seashells and things like that, rather than cremated remains. Because it's easy. It's easy, right? It's hard to say, yeah, that's my loved one not going down in a hole. But it's easy. So because how easy it is to have a scandal in these areas, then we see them. When it comes to pre-need, we see a lot of scandals with pre-needs and where those funds go. Why? Because it's easy to have a scandal. And the same thing goes for this, right? The coroner system is an elected official. They do not necessarily have, you may have a funeral director, but a lot of times they don't have a background in what we do. They don't have a medical background especially. Some of them may, but they don't. And because of that, we see a lot of scandals, or we see a lot of legal issues that come from this type of system. So not all the time. Again, I'm not saying all of them. But if you're going to see a scandal, you're going to see it typically fall under certain categories. So we have our hawk-eye watching certain areas to look for those issues. All right. The funeral director followed that advice and embalmed the body before the next of kin could be located. When the next of kin learned of the embalming, he sued the funeral director for mutilation of the body. Because the embalming had not been authorized by the next of kin, the court permitted the plaintiff to bring the action. The court held that it was not a defense for the funeral director to claim that the embalming was beneficial. Another one, Shea versus William F. Howard Funeral Home. This took place in Florida in 1980. The funeral home embalmed without permission and in violation of the decedent's Jewish faith. Ooh, that hurt. The funeral director testified that he was aware that the deceased was of the Jewish faith, and because of such knowledge, saved 2 bottles of blood to be buried with her. Oh, that hurts. Okay? They tried to rectify it. They tried to do the best they could and tried to justify by just giving the blood with that. Okay? All the blood goes. Okay, 2 bottles of blood is not nearly what comes out of the person, first of all. The court permitted the plaintiff to bring an action finding that there was an issue for the jury to decide as to whether the funeral director was aware of the adverse consequences of his decisions to immediately embalm that body. Okay, he tried to rectify it. He did try to rectify this, but was he in the right to do this? Second, although less likely incidents of mutilation involving funeral directors can occur with an unauthorized autopsy. An autopsy is a post-mortem examination of the body, usually for the purposes of determining the cause of death. If the autopsy is not authorized by the next of kin, or is not duly ordered by the coroner in a lawful discharge of his duties, it constitutes an actionable tort. Although funeral directors do not typically conduct autopsies, they may still be liable if they participate in it or consent to it without the authorization of the next of kin. Now, the legal system can say, the medical examiner can say, we're doing an autopsy. The family and nobody has any say in that because the legal system states that we need to do an autopsy in this circumstance for medical legal reasons, okay? So they are allowed to do that. But in these autopsies, they'd be primarily referring to a private autopsy. Private autopsies, or the medical examiner did an autopsy and it wasn't justified as to why that individual needed an autopsy. You might be running into an issue. But Okay, we're referring to like private autopsies, things like that. Mayers versus Clark. Okay. 1906 held that the funeral directors who, without permission of the next of kin, permitted autopsies to be performed will be jointly liable for the persons performing the autopsy. Likewise, in Palenque versus Bruning, this happened in 1900, the funeral director who assisted in an unauthorized autopsy was held jointly liable. Okay, so again, you're authorized. And there, again, it continues on. There's a couple more cases that took place as well that are under the same precedent. Right. Injury to invitees. So an injury to an invitee, a funeral home owns the duty to care for each invitee to the funeral home to maintain the premise and all of that. So again, if someone were to go along and let's say there was a pull in your carpet and they tripped and fell because they got their stiletto caught on that, face planted, you're liable for that. If if you could justify and say their stiletto was roughed up and it caught their carpet, now come back to the same thing as, did you make your locks unpickable? Seriously? Alright, it was, in my view, it's their damn problem that they came across, they were wearing stilettos with a roughed up edge on them, and that got stuck on the carpet. But, did you make your carpet uncatchable? No. It's a carpet. It gets caught. But did you make it uncatchable? So, that's how they could look back at these kind of things. Again, like the bricks on on your funeral home, the staircase rather, on your funeral home, the stairs or ramp on a church. Were they broken off? Could the stair move or shift? Could the person fall? Is the railing sturdy enough? Is there any ice? Is there any snow? Is at the church, at the cemetery, at the funeral home? You need to handle all of that. I don't wait for the church or the cemetery to do it, because they're not clearing any of that. Okay, they might go through with a plow in the cemetery, but they're not going to clear all the way to the grave. We hope that they would do something, but they're not getting on a shovel. If you want that done, do that. Because at the end of the day, is the cemetery liable? Yeah, the cemetery is liable for their own property. But were you conducting the service? Yes. Was the church liable for their own property? Yes. But were you the one conducting the service? Yes. So is your paramount duty to ensure the safety of all attendees of the funeral? Yes. It is your paramount duty. So regardless of where you go, it is your paramount duty that you need to make sure. So always take every precaution you can and be hypersensitive to everything that could possibly be an issue to ensure that that doesn't happen. That includes trespassers. So maybe somebody went into a part of your funeral home that they didn't belong into, and they got injured, or if somebody walked in, make sure your prep room is locked. If somebody were to walk into that prep room and they were to see something, they could sue you for mental anguish because they were able to get to that prep room. It happens. Or they were able to make it into the second parlor and they saw somebody that was not their loved one in that other parlor. They saw all the bodies lined up for cremation. That was mental anguish. They can claim mental anguish is one of those words. They could make it whatever they want it to mean. They have mental anguish because of anything, and they could make something up and they will still win in court because mental anguish is not measurable. Absolutely not measurable. Alright? So we've had cases like Shipman versus Norton where the woman stepped off the porch and tripped. We have cases, Philippica versus Plumbum, where the funeral home was liable for injuries resulting from an icy walkway and ramp. So these are all cases that come up that are showing that there's precedent. Like, they will sue you for this. Okay. So be careful. Injury to pallbearers and clergy. I know there was the pallbearers falling into the grave. We saw that. There was a video that circled around social media. That was a big issue. That cemetery should have never had. That was a big thing. Those planks, flipped over and went in. The hole was dug too big. There was just too much going in to that issue. That should have never ever happened. Okay, so that was negligence on everyone's part for that. Now, if you do have a grave where you're like, this is not safe. Now, if you've ever carried a casket, and many of you I know have, you carried a casket and you go over, you know how hard that is to walk on those planks, and then you're trying to put down that heavy casket. Okay, that's not easy. It does create some effort there. So if that's a risk, put the casket off to the side. Do the services off to the side. Go get the church truck out of your hearse. Put the church truck. Do all your services on the church truck, and then afterwards have the cemetery workers be the ones to move the casket over with you. The funeral director and the cemetery workers move the casket over and put it on that strap afterwards, and then do it properly. Or have the pallbearers put it on the church truck. Make it part of the ceremony. Just say, we're going to do this, we're going to, make it part of the ceremony, and then they say do that, and then part of the ceremony is that, two funeral directors or the assistants lift the casket and ceremoniously put it on the straps. What it does is it prevents, especially when you have old or, decrepit or people lacking mobility, you get a lot of that, right? We have people that are dying and their loved ones are not any better condition than they are some days. So, do I want them near that open grave? No. You look at it and they say, okay, for this service, I see all these pallbearers. Let's put the church truck out. Put that out, make it safe, and then the funeral directors, cemetery workers, all of that ceremoniously over into the grave, okay? And you do it, so nobody's gonna drop. All right. So again, all of those things you have to consider, and handles falling off. Staircases are steep to churches, things like that. So if you have things, it's okay if you're looking at your pallbearers and you're like, these people are going to have a problem. Use handicap ramps if you can. Go through the back doors of churches if you have to. If that's where the handicap ramp is, that's fine. But honorary pallbearers is a good word to keep in your vocabulary. So at this time, we say, okay, the pallbearers lift the casket out, they get it onto the church truck, they roll it over the stairs. At this time, we have them step away from the casket. We have the funeral assistants that are hopefully in good health carry the casket up the church stairs. Church truck gets run around. They put them down, put it down on the church truck, and then the pallbearers now gather. They all got to get up by the railing, or they use the handicap ramp. They get up. Then you pause. You get them all around the casket, and then they can process it with their hands on the casket. They all get to play pallbearer, but their hands on the casket as it processes down. It's just a good way to prevent injuries. And because if they say, well, you say, well, they wanted to do this, they chose that they wanted to be the pallbearer for this. Yes, they did. But at the end of the day, you let them do it. And it was your job to secure their safety and ensure that they did it correctly. And ensure that there was no injury on that. We've seen artificial grass get kicked up at cemeteries, things like that. That all comes issues. Okay, mental anguish. Again, this is a big word that we come into. The different things that they're going to look at under mental anguish would be, what's the physical impact that we're looking at? Was there an intentional infliction of mental distress? Okay, I hope it was not intentional, but that does fall under that. Was there a contractual breach? So what contract you do, does it be a written contract, or whether it be oral or written or whatever, is there a contractual breach? And was there negligent infliction of mental distress? Did you cause mental distress because you were negligent? You didn't do part of your job. And were there punitive, they award punitive damages for this. Okay, that means that there was no value. It's not saying, you ruined my book and my book was $300. What that's saying is, I saw something and you're paying out money. The funeral home's paying out money as a punishment. And yes, the family gets that money as a reward for their problems, or as a retribution for their problems, is what it comes down to. Okay. So we do see that. All right. So in those cases, going back to, was there a physical impact, right? So can they be proved that there was a physical injury that was caused? Now, that could be medical, right? So we talked about the case where the person had a heart attack. That is a physical injury that takes place. So that could be proven. That could be proven that there was physical injury that took place because of your withholding of that body in that case, or whatever the case may be in that. So we had, or was there a physical impact, actions and things like that you did, wrongdoing that you did. All right. Now, I'm going to read this off. The necessity of showing physical injury prior to any recovery for mental anguish is Yeah, slowing. I think that's a typo in the book to us. Slowly being eroded in American law. Okay, that's what that was supposed to say. So meaning that what this is saying is that you're screwed. Is what this comes down to, because there was a point where you had to prove that something came from it. You can't. Somebody couldn't walk in to the parlor and say, like, I suffered from this, right? I had an asthma attack, I had a heart attack, I had a stroke because of what I saw. They can't just, like, there was no, like, what they're saying basically, what was the physical impact, right? So the court of law always looked at what was the physical impact on the outcome, right? That you had an actual panic attack that could be proven, and what did that panic attack do to you, and things like that, right? It's physically, something physically happened. But how many people today, right, basically, I mean, raise of hands of how many of you, we can't see this, right? How many of you have anxiety? Now the question is, what does your anxiety cause? Does your anxiety cause something physical when you have a anxiety attack, a panic attack? Does there something physical that goes along with that? That could be measured by the EMTs arrive, they check your blood pressure, they check your pulse, they check your breathing rate, they check all of these things, and they say something physical is actually taking place. That is a physical impact. Having physical impact eroded from the legal system is not a good thing for you, okay, if you're being sued. It's not. What that allows is the family to walk in and say, oh, I was distressed that my loved one was wearing a pink shirt and not a blue one. It caused me mental anguish. It was horrible. There was no physical impact on that. I'm sorry, but I'm sorry that they were wearing the wrong color shirt. But that was no physical impact. The fact that you saw a dead body, we should expect that they look dead. But, oh, that was not what I was expecting. I was expecting him to look perfect. And he did not look perfect. He looked dead. No kidding. He is dead. But the family's not bringing you to court because they're looking and saying, but I was distressed. But did you have a heart attack? Did you have a stroke? Did you have a panic attack? No, you did not. Okay, so having that eroded is a problem for you if you're being sued. Because they can claim anything they want and say they have mental anguish, and you're at fault. And that is not a good thing. That is really, really not really a good thing for you. All right, intentional infliction of mental distress. As the physical impact rule has been eroded, courts have begun to recognize the tort of intentional infliction of mental distress. So did you intentionally do this? This allows for recovery of damages for mental anguish when you intentionally, you had intentional, wrongful, outrageous, reckless, malicious, that you would have caused severe emotional distress. Now, does that mean that you intentionally left a decomposing body in a casket, that you intentionally did that so the family would have to intentionally see a leaking, decomposing body? No. But did you intentionally not do your job by negligently embalming? Yes. You intentionally chose to not embalm that body the way that you were taught to embalm it. You did it quick. You didn't do it properly. That body didn't get good distribution. That you didn't do the proper, building out of the face afterwards. You didn't. You said, the legs. Nobody ever sees the legs, and you let those legs start decomposing and leaking because you didn't do your due diligence to make sure that those legs got care. And if you did everything you could and those legs were still not getting it, then we topically treat it, we hypodermically treat it. We do everything we can to make sure those legs get it. If you embalmed and you're like, there's a lot of problems with this, let me just throw them in a Unidol, I'll throw them in plastics. And you throw that individual in plastics, and then there's problems. I'm sorry, but that's negligence. You intentionally decided to put them in plastics. Now, yes, the textbook may say you can do that. but you intentionally chose to negligently not bandage that person up, negligently chose not to prevent all leakages with glue and web roll and and plastic wrap and all of that. You negligently didn't do your job. So yes, that was intentional. And same thing goes for funerals and things like that. You intentionally didn't call the police to when there was going to be a potential disturbance. You potentially didn't do certain things during the service. You intentionally didn't call things. You intentionally didn't, publish the obituary on time. Now you may have negligently did that, but you decided when you were going to publish that. All right, so that could become an issue. All right, so in that, let's use intentional. So in the case of a state of Harper versus Orlando, we did talk about that earlier, right? Where the absence of physical impact, mental anguish, for negligent funeral directing could not be recovered unless plaintiffs allege the defendant's conduct exceeded all bounds reasonably tolerated by society, such as to suggest malice or the entire want of care or great indifference. Okay. So that was something we had talked about earlier. Versus Rubin, Memorial Chapel said that wherein the complaint alleged that the defendant funeral director had put a body other than the decedent's in decedent's casket and burial clothes, that when confronted with this error, defendant tried to convince the plaintiff that the body in question was indeed the decedent, and that after removing the burial clothes from the wrong body, the defendant simply threw the clothes over the decedent's unprepared body. The court ruled that the allegation in the complaint implied sufficient malice to permit recovery for pain suffering from mental anguish. They took the clothes and just put them on top. They didn't even dress the person. That's intentional. Okay? Contractual breaches. So we have cases where, again, you breached your contract. You had something that you implied that you were going to do. So Lamb versus Singleton, we had talked about that, right? The court noting that the personal nature of the funeral contract and the fact that the contract itself puts the funeral director on notice that a breach thereof would probably result in mental anguish, held the damages from mental anguish could be awarded in cases involving breaches of funeral contracts. Same rationale was applied to Mayer versus Nottinger. We talked about that one earlier as well, right? Wherein the court permitted recovery from mental anguish as a result of a contractual breach, even in the absence of physical trauma, because the contract in question was not concerned with trade and commerce, but with the life and death and matters of mental concern and solitude, which should have put the funeral director on notice the mental anguish would result from this breach. Okay? So again, you can see that breach of contract, mental anguish, negligence. These are words that we consistently see over and over and over again. So they're the most common things that you're going to get sued for both sides of the house. Okay. Allen versus Jones, so this is an exception. After reciting the fact that the funeral director should be on notice that mental anguish will result from his breach, the court added that that the award of damages from mental distress against the funeral director serves as a useful and necessary means to maintain professional standards in the funeral industry. It added that damage from mental anguish is often the only method to compensate victims of wrongful acts by funeral directors. Okay, so just to give you an idea of the legal wording and how they word it, and how that could impact you. And again, any loophole in the law is not in your favor. Okay, so negligent infliction of mental distress, same thing, right? So we have cases where damages of mental anguish can be recovered when the defendant's wrongful conduct is so malicious or reckless that it appears intentionally calculated to cause mental anguish in plaintiffs. Right? But courts can go beyond that. Right? That's the thing. Courts can go beyond that, and they can look at the recovery of damages from mental anguish in cases where the wrongful conduct consists merely of simple negligence. The fact that you just simply didn't do your job. Negligent embalming, negligent funeral director, all of that. So let me give you another case. Corrigal versus Ball and Dodge Funeral Home. So this took place in Washington in 1978. The Washington Supreme Court permitted an action for negligent infliction of mental distress against a funeral director. The court held that proof of simple negligence, as opposed to malicious or reckless conduct, was sufficient to recover damages from mental anguish. A simple result was reached in Holson versus Heritage Mutual Insurance. Right? We had mentioned that one earlier as well, where the court had held that the funeral director could be sued in Wisconsin under the theory of negligent infliction of emotional distress. Okay, so just negligence, simple negligence is all it takes. So again, we see all these cases that play a role in that. Punitive damages, again, it's just to give you that word, it's just looking at the fact that there was no physical. You didn't damage my car. There's not, what's the repair cost and what's my medical cost. Punitive damage is just strictly saying, what do we think that your mental anguish is worth? That's it. So that could be a lot or that could be a little. And they will ask for the maximum. When you have an insurance policy at your funeral home for general liability and things like that, it's usually about $1 million policy. That means that the court is going after you for $1 million because that is what it's allowed to go after you for. Right? They know they can get that from the insurance company. Right? In Mayer versus Niger, we have been talking about this case a couple times here. However, the court permitted plaintiff to seek punitive damages because they had alleged wrongful conduct that was committed with a willful and reckless disregard to the rights of others. Golson versus Lincoln Cemetery, an award of punitive damages was upheld by the appellate court. So basically, it means they had gone. Appellate court means it was appealed, right? It means that it had gone to court. You didn't like the decision, and therefore you didn't like the decision. You appealed that decision and brought it to a different higher court, an appellate court, where the appellate court they look at prior cases and they see if they can come with more evidence to overturn that prior decision. Upheld by the appellate court, which means that the appellate court had stuck with the original decision. They didn't change it. Because it found that the defendant had shown a complete indifference to or a conscious disregard of the emotional well-being of the plaintiff. Right? So, something to consider. All right. So, just a few words. So, liability for funeral expenses, just a few terms. Primary obligator is the person that's primarily obligated to actually pay and do all of that or to provide services. So, we do have some states that do put a limit on how much you can, the funeral bills can be. The other thing, too, is let's say you're going against an estate. And when we're filing and we say, all right, well, we have primary rights to go against a state. When a state goes to probate, you could go to court and you could say, look, I need to be paid my funeral bill. And you do have primary rights to get paid. You do. As a funeral home. So you actually get paid at the funeral home before hospitals get paid, and you get paid before that money can be distributed to do anything else. The family cannot touch that money, and it can be locked up. You can have the court lock up that estate money before it gets spent anywhere else, because once it gets spent, you don't have money. So you can ask the court to lock up those funds for you to get paid before that money is used to pay off anybody or anything else. However, the key word is you have to have reasonableness of that funeral bill, which means you look and say, ha ha ha, this is going against the estate, right? Now, here's the thing. You see a family, they show up when they're like, yeah, look, we're driving Dad's Bentley. We got a nice car. Thanks for this. And when they got that car, you're looking at it going, hey, there's some money. No, Dad spent all of his money on the Bentley. Dad may have had a Bentley, but Dad spent all of his money on gambling. Or maybe all of the medical expenses, all of that paid out. Maybe Dad already distributed all of his money to his kids, so it's not in his estate. All of his money has already been given to his kid, so he doesn't have an estate. Okay? So you have to consider these factors. So you're looking going, well, I'm going to go to court, and the court's going to have to give me everything, so $20,000 service it is. Let's have some fun here. I think you need this casket. I think we should have all the bells and whistles. Well, at the end of the day, you go to court. And the court turns and looks and says, I'm sorry, Mr. Shea, but you are charging this family $20,000 for a service. Yep, that's correct. We gave them the bells, the whistles. They gave them the presidential casket. They had the tent. They had a marching band with the bagpiper. They had it all. And you know what? The judge looks and goes, all right, Mr. Shea, I don't care how many frills, and I don't care how great that service was. You had an estate. They were not paying the bill, and then nobody signed over and saying, we're going to give you $20,000, here's our credit card, here's our cash. You knew that this was going to an estate. That is correct, Your Honor. I knew it was going against the estate. And they got all of it. Mr. Shea, I don't think you're understanding this. That is going against the estate. And we've looked up the prosecuting attorney in this, the other, thanks. The attorney has looked this up and has determined that the average cost of a funeral is $8,000 to $11,000. For a good, decent, high-quality funeral is $8,000 to $11,000. That's right, but not for this service. They got the best, sir. Your Honor, they got the best. Yes, but you're understanding me. That $20,000 is not reasonable. They did not choose to have a $20,000 service. They did not hand you $20,000. They did not choose to do that. You provided them a $20,000 service, and now you're expecting compensation. We will, however, provide you $8,000. But better yet, you know what? I think that your funeral home, we were looking at your GPL, and we found out your funeral home could provide a good quality direct cremation for $3,500. With services, that direct cremation goes up to, services up to $5,500. So, you know what? They didn't ask for a burial. They just asked for a service. So, we're going to give you did provide services, and we thought that was very nice. So we're going to give you $5,500. But, Your Honor, no, not Your Honor. You had a reasonable right to provide them a service within their budget. And therefore, a reasonable service nationwide is ranked at $5,500 for cremation with services, $3,500 with a cremation without services, and a burial for $8,000 to $11,000. Sorry, sir, but that is what you're going to get, Mr. Shea. Okay, so you can see how that would play out. Okay. So we do have circumstances. Let me give you a legal case that goes under the liability for funeral expenses of the decedent. Okay, so I'm going to give you a couple cases here. So common law rule is that a husband and father are primarily liable to pay the funeral expense of a wife and dependent children. That is common law. Well, you'll love that one in 2025. But common law states, so if you were to go, common law does state that the guy is still, it's a male society in this one. The common laws date back, obviously a very long time here. But you could go to court, and if you and you could argue that a father is responsible for his wife and children, okay, for the expenses. This is true I'm just reading the rest of the sentence here. This is true regardless of whether the wife or child leaves an estate or whether the husband or father signs the funeral contract. They can still be going after the court of law, can still go after. Moreover, the husband or father cannot recoup the funeral expenses from the decedent's estate. You love this. In other words, the husband or father is primarily liable, and the estate is secondarily liable for the funeral expenses. Okay? So, obviously, statutes can supersede the common law. Statutes in some states and all of that, obviously, make the estate primarily liable. As it should be, I think. We're in a different society where things are, have changed there. So, primarily, the estate should be primarily liable. That makes it the expense of the actual decedent. In their circumstance, where they should be liable for that. So, in this case, let me skip ahead here. In general, under common law, there is no duty on the wife to pay for her husband's funeral. So, the husband's estate is if the husband's estate is inadequate to pay those expenses, um, then she doesn't have to pay. Again, that's just common law. It doesn't mean that's state statute. State statute will supersede that. So keep in mind, don't try to run with that. That is common law, but that's not state statute. All right. An example: Davis Turner Funeral Home versus Cheney. So in this case, the funeral home is suing the family for money. A widow who refused to pay for her husband's funeral was compelled to reimburse her stepson, who paid for the funeral. The court held that under Ohio law, a wife is statutorily obligated to pay for the funeral expenses of her husband when the estate is insolvent. So Ohio did overrule the common law in that circumstance. So we do talk about contractual liabilities and things like that, and you do have to follow obviously all that. The executor or the administrator. So an executor or an executrix, or an administrator or an administratrix of a will is the person that would administer that individual's estate. Now, when you make your own will, I decide that my brother Quasi, better known as Quaz, is going to be the executor. That's not his real name. Don't worry. The executor to my will, and he is the executor to my will under his actual legal name. Don't worry. So, but I do say that Quaz is going to be the executor to my will. I've determined that. That means if something happens to me, that he's the one that's going to administer that. But if you don't have an executor, or if now that has to go to the lawyer brings that to court and said that this person never determined who was getting what, then now the court determines, and they look and they say, okay, we're going to appoint an administrator or an administratrix. That may very well be an attorney. The attorney may be appointed as the administrator or administratrix in order to distribute the estate of the decedent, or it may be a loved one. They may turn and they say, Quaz, you are, Dan's, next thing, we find you of sound mind, we're going to appoint you to have the obligation of properly distributing his estate and taking care of his affairs for him, post-mortem. So you can have something like that. All right. And then for Davis Turner Funeral Home versus Cheney Supra, the son had been appointed as the executor for his father's estate. However, in signing the funeral contract, he had not stipulated that he was signing as the executor of the estate. Okay? Therefore, he was personally responsible for paying the bill. Fortunately for the son, the court found that the funeral expenses were ultimately the responsibility of the surviving spouse and ordered her to reimburse the son for those expenses. So things like that can happen. All right, liability estate. So the state and local governments may also be responsible for the law for some payments for indigent funerals. So in this case, we deal with, depending on your state, Massachusetts we call it DTA, Department of Transitional Assistance. Rhode Island has something else, so all these states, they do refer to it differently, but basically welfare. And you show up your card, they photocopy the card, we put in all that information, and we request funds for the burial or cremation of indigent individuals, low-income individuals, in that case. All right. So looking at cremation, so authorization to cremate, again, that this is a final disposition. This is irreversible. And since it's irreversible, we have to consider that the irreversible can pose an issue with if you make mistakes, right? Obviously, if you misidentify a body, things like that, that's all irreversible. So one of the things is you need to have authorized authorization to cremate. You don't need authorization to bury it. If you have a body, you're like, this body's sitting around, then get that body buried, because we can always disinter that body. We can always exhume the body, and we can bring them wherever they want them and do whatever disposition method they want after the fact. However, cremation is irreversible. So you need the proper authorizations, you need proper permission from the proper person, and then what happens when we're trying to get permission? What happens if that individual is not available? I've had cases where they had a sibling that was estranged, or so they say, and they say, look, the sibling is estranged, she's not a part of any of this, so the siblings all sign the cremation paperwork, they sign the embalming paperwork, they sign everything, giving permission for us to do our job. And then, that person that they say is not part of it, shows up to the services. Okay, and they didn't argue, it all went well, but they were there. So, you can't tell me you don't know where your sister is. So the best thing to do is always have a letter that states, you can type it up, that states, I do not know where my sister is, she is blah 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 blah, and give a story about it. And then all of those siblings are signing that, because when something happens and that sister comes about and says, hey, I had rights of disposition and I didn't want this to happen, why did you exclude me from this? Then, and in our case, I've had this where they showed up, and obviously they knew they weren't really welcome in the family, and they didn't ask to be, and that's fine. But that could come back to bite you. So have that paperwork and have it notarized that states that they are identifying that you, and if you have another notary or send them somewhere else, if you're the notary, I would just have somebody else do it, just so you can say, like, hey, I'm not the one that notarized it and wrote the letter. And, have them sign it. And that states, like, they don't know. Something comes back and you say, look, they told me that they don't know where their sister is. But how do we identify this? We have identification of the decedent. We have to identify the authorizing agent. Make sure the authorizing agent is who they say they are. Make sure they have the right relationship that they are. Make sure that there's not someone that's more of an next of kin that could come back. So again, you are saying that this person is telling you that you've asked these questions, and you say, okay, if it's the spouse, that's pretty straightforward. If it's the child, I'm going to ask, do you have any siblings? I need to know if they're siblings. Now, they may not want the siblings in the obituary, and they may not tell you that they're siblings because they don't want them mentioned in the obituary. That's fine. We can omit them, but I need to know if you have any siblings for legal paperwork purposes. If this is like, if maybe this is the siblings of the decedent, I need to know if they have more siblings. If this goes to any level, remember that signatures go to the entire level that it is. It doesn't go down to one child. It goes down to the entire level of children. If it goes to siblings, it goes to all the siblings. If it goes to grandparents, it goes to all grandparents. If it goes to parents, it goes to both parents. Okay? So both parents sign it, all siblings sign it, all children sign it, both parents sign it, all grandparents sign it, all aunts and uncles sign it, all nieces and nephews sign it. Whatever it is, it has to be all of that category. We do have to remove medical devices. All of those are legally, so again, you can, I'm sure you guys know by now, a lot of the crematory stuff and all of that. To disinter has to be in the public's interest. I don't really want them there, that's fine. You can have them disinterred, you can pay the fees, and it has to go to court, and the court has to rule and say that, yes, we're giving permission for that person to be disinterred. But that does have to go to court in order to do that. But it can be for disinterment, can be for the public's interest, it can be for private purposes, it can be for reinvestigating things like a medical examiner wants to look at them for, that. We do have people that are unauthorized disinterments. This is a legal case when I taught this class. There was a legal case that came up as part of the reports at the end there, the cases you report on. And it was a deranged individual. But he basically found an obituary of this really hot, according to him, really hot, good-looking girl in the obituary. Okay, this is the way he words this in his court documents. That she looked amazing, and he knew that she was his soulmate. This was his soulmate. He could feel it. He saw her and said, my soulmate just died, and I missed the opportunity to be with my soulmate. Okay? He was heartbroken. So he went to the cemetery and he disinterred her. And he dragged her out to the woods. He dug her up in the cemetery, disinterred a body, and he dragged her out to the woods, which is where people said, hey, why is that grave open and what's happening? We just saw some guy dragging a woman out into the woods. They caught him, they arrested him. That should have happened. And in his words, it was obviously a little deranged, but in his words, he met his soulmate and he just needed to be with her. Now, let me describe this. She died in a motorcycle accident. So, just speculating here, she probably wasn't in the best of conditions. Okay? So, he was dragging her around to the woods to, I don't know if he did or if he was about to proceed to do, very inappropriate things to her. But that was his intent. And, so things like that do happen. So we do have to obviously safeguard bodies and make sure that things don't happen, all of that. Right? Funeral homes obviously have to be regulated and all of that. You do have to have proper licensures, and if you're trying to do things at a facility that is not properly licensed to do it, you're liable for that. Now, the other thing with that